I'm seeking an indulgence of your lordship, my lord. That item 33 listed today as per my prayer before your lordship, my lord. There's a connected IA in that case, my lord. Can it be called for?
33.
Yes, ma'am.
Okay, all right.
The connected IA. Lord.
My lord, I beg to mention one MSc appeal, my lord. Here it was last listed, my lord, 5/12/2024, my lord. So matter may come in.
Oh, hearing or
but admission for fixing the order for order, my lord.
order?
My lord.
When do you want?
Any that subject to lordship.
My lord, I am mentioning an urgent RFA, my lord. My lord, it was filed on 18th of July. But the thing is, my lord, the one execution has been filed and it is fixed on 5th of August
For?
for execution, money execution, my lord, against me, my lord. So I am praying for listing of this RFA on 30, 33, my lord, 30 July. Otherwise, my lord, it will be influx of.
Okay.
Of last.
Yes.
My lord, for listing of the my lord CRP IO method, my lord.
When?
My lord, Monday, my lord. First August to আগত দিয়ক না দাদা অলপ।
Yes.
So I beg to mention item number 11. I'm for the NLM, respondent number 1.
Item number 11.
Item number 11.
Your name, please.
SJ Rajbangsi.
SA?
SJ Rajbangsi.
Mr. So-and-so, learned counsel appearing for respondent number 1.
Yes.
Respondent number 1 with consent from the other side, price for listing the matter. When?
After 2 weeks.
After 2 weeks. Fair load.
One another item number, Your Honor. Item number 12.
Same pair.
Yes.
Okay. After 2 weeks.
May I please, your lordship? I beg to mention for listing lordship a RSA. In
Right.
this RSA lordship, yesterday it has been issued for execution of the suit land lordship. Can it be on 25th lordship? 25th? 27 lordship. Therefore report has been fixed on 7th August.
Oh, 1st of August, so you will take it up. No problem.
1st August, lordship.
Yes.
May I please, Your Lordship, I beg permission for listing of CRP 10/2023 for admission hearing.
When?
If not possible, this Friday or Monday, Lordship.
Next Monday.
Yes, Monday.
May I please, your lordship. Lordship, in item number 27, lordship, we have filed an IA, the order 41 rule 27. That has not been listed along with, not been tagged, lordship. In fact,
27?
yes,
Okay. When did you file?
we filed it on 24/6.
All for. Yes.
May I please, Your Lordship, the concern of the other party, I beg to mention item number 15 to 18, Your Lordship. Lordship, the learned counsel, Mr. P. Gogo, appearing for this matter is not available today due to a personal difficulty, Your Lordship.
15 to 18.
You, Lordship, may have the matter.
Already there is one adjournment request.
May have the matter on 4th of August, Your Lordship.
1st of August.
4th of August.
4th of August. Okay. As agreed by learned advocates of both the parties, this shall list the matter on 4th of August.
May I please, your
Yes.
lordship, I pray for listing and make appeal for orders. Any day, as per convenience. I'm so
Yes.
obliged.
Lordship, I beg to mention item number 9.
30.
19. Lordship, we have applied for certified copy and the process has not yet been completed, so we require some more time.
You inform the other side.
Lordship, I'm representing CBI.
You are for. No, you inform the other side, respondent.
I'm for respondent number 4, my lord.
Okay. Any objection? No. When do you want?
After 4 weeks.
After 2 weeks. Okay, as agreed by learned advocates of both the parties, this shall list the matter after 2 weeks. 2 weeks.
Lordship.
Yes.
They are for listing, Lordship, MSc appeal, Lordship, for hearing, Lordship.
When?
29 or 31, Lordship. Lordship, old matter, 2015 matter, Lordship.
Short date COVID, last week.
May be pleasure, Lordship. Lordship, I beg to mention for listing one MFA in hearing column. Lordship, it may be listed on 14th of August.
Yeah, please, Lordship, my lord, I beg to mention for listing, RSA, it is filed on 24/1, my lord. No, there are some minor defect, my lord, I have rectified. No, that will be listed on 25th, my lord. There is a stay petition also, my lord. 25th for. First, I was, it will be late, my lord, execution processes, we have heard, my lord, that.
Yeah, to what stage the execution proceeding is pending?
My lord, the notice, I think summons has been issued, my lord.
Someone issue.
Yes, my lord.
Don't worry then. Yes.
May pleasure, Lordship.
Obliged, my
I beg to mention for listing, my lord, I am the respondent, my lord. The insured company has filed an appeal. My lord, that was a dismissed for non-prosecution in the year of 2010, my lord. Then after they have filed a restoration petition with IA number 147719, my lord. Then after it was not listed, my lord. So it may come, my lord.
When?
My lord, any date, my lord, next week. 6th of August.
Okay.
6th of
Yes,
August.
Mr. Mahmood.
Lord, my lord, we have filed a review petition against the order passed by your lordship. My lord, in RSA, my lord, some decree has been passed in favor of the respondent. We are the appellant. They are going to file execution case, but the boundaries of the suit land are totally different. So we will be in trouble. Our building is there. So it may kindly be listed tomorrow, my lord. Very urgent matter. It will come for admission.
Well, Thursday. Thursday.
Highway.
Thursday.
Sorry.
Day after tomorrow.
Sorry, man.
Items for referral to mediation. Item number 1.
Yes, can we refer the matter to the mediation center?
We have no objection.
No objection. Yes, madam?
No, Lordship, we have no.
Is there any sense of the matter being compromised?
Yes, it can be.
Can be.
It can be, madam.
Okay. Heard Mr.
Jay Sharma.
Sharma,
Jay Sharma.
learned counsel for the appellate, and madam
Ms. Sharma for 1 to 5.
S. Sharma for respondent number 1 to 5. This matter is listed today under the column for referral to the special mediation grade, that's mediation, in inverted comma, for the nation. The learned counsel for both the parties submits that there is chance for effecting a compromise between the parties, and they have no objection in the event of referring the matter for mediation. They are taking note of the submission of learned counsel for both the parties. It is provided that the registrar lays the matter for before the mediator. And should we fix a date?
Yes, that may be fixed.
Yes.
When? First week of August?
Take that. After 2 months.
A time may be given within that period. The mediation
Mediation
will be
should be
completed, my lord.
After 2 months, Lordship.
Okay. The parties are directed to appear before the mediator, or mediator will issue notice to the party.
Yes.
Yes, yes. That is the procedure.
That is.
Okay. Yes, madam. Huh?
We have a secretariat here in the High Court.
Mm.
So that secretary lordship will send it to the High Court Mediation Center.
Mm.
From there, they will be sending the notice, not the mediator. To the mediator also, they will notify. They
Okay.
will select a mediator from the panel of mediators.
Center will
Okay.
inform the party.
Okay.
আপনার কেউ বলবো? কেউ
Uh, we will direct the registry for sending the matter. Yes, madam.
Yes.
We will direct the registry to send the matter to the mediation center.
Yes.
Registry is directed to send the matter to the mediation center, High Court Mediation Center.
It would drive us.
And the mediator, should we fix a timeline?
Lordship, as per the, since this is under the Supreme Court,
Yes.
already a timeline is given in that. But Lordship can fix a date so that the parties can appear on that particular date in the mediation center. So that they know,
Okay.
though no time is
Okay.
wasted, Lordship, because
The-
here,
Parties are directed to appear before the mediator on or before
29 of this month.
29.
Yes.
not on or before Lordship, on.
On. Okay. 29. 29. And is there any requirement that a mediator should complete the process within a particular period?
That will be there in the mediation referral, Lordship, the one which will be sent by the secretariat, because they are writing there that how much time. Because all the mediation,
So,
all these cases are to be completed by 30th September latest.
Courts are not supposed to fix any timeline.
It's better not to, they will do the.
Okay.
Number 2.
May I please, your lordship, matter may kindly be taken up for hearing, my lord. Because
So this matter is also listed under the same column. Is there any chance of?
appellant is not interested, my lord. Appellant is not interested. Matter may kindly be taken up for hearing because LCR is received. On earlier occasion also, matter was referred for local adalat. But
Referred for?
local adalat. So their settlement failed.
Look at a lot.
Yes, my lord. So this time matter may
They could
kindly be
not
taken.
arrive at any settlement.
Yes, my lord.
Okay.
Date may kindly be fixed. Issue.
For hearing,
Yes, my lord.
pardon, Mr.
K. Kulita.
Learned counsel for the appellant and madam,
FN Jaman on behalf of S. Roy.
learned counsel for the respondent,
Respondent number 1, your lordships. Respondent number 1,
respondent number 1.
insurance company.
None appears for the respondent number 2. It is submitted at the bar that the matter was earlier referred to look at a lot, but the parties failed to arrive at the settlement. And as such, there is no chance for compromise, even if the matter is referred to mediation. Then it is contended that the matter may be listed for hearing. Accordingly, it is provided that recess and this
In
matter
this month, my lord.
for hearing.
Date may kindly be fixed, my lord. It's long pending.
19th of August.
19. Can it be fixed on 26?
On be your blessing, lordship.
Here, this matrimonial appeal, my lord. Learned counsel for legal aid who is appearing MS MJ and he's out of station. But I have telephone discussed with him. The matter maybe can be referred. She told me for referral. This is for the referral.
Who is for the respondent?
That's why my submission is this one. Learned counsel MS Jain is appearing on as a legal aid counsel on behalf of respondent. She is out of station. Telephonely, I have discussed with her. She had given consent, but however, it will not say satisfaction. Otherwise, maybe adjourned.
No, if you talk with her yesterday, when did you talk with her?
Day before yesterday when list has come.
Okay.
So maybe
She
otherwise,
has
my
no
lord,
objection.
otherwise, lordship, it will be better because it's a matrimonial matter. We have to take on board. So, though I may maybe refer this on adjourn next after 1 week it may be listed.
She is
Because-
absent today.
Hmm?
She is absent today.
She's absent means she's out of station. She
Out
told
of
me.
station.
That's right.
So let it be on next Monday then.
My lord.
We'll hear her.
Yes.
Heard Mr. C. Borua, learned counsel for the appellant.
Appellant, my lord.
Non-appeals for the respondent on call. Place the matter on Monday.
Little later because she may 10 days after 10 days.
Vote for this.
My lord. Oblige.
Matter number 4.
Please, your lordship. My lord, in this case, we have no objection, but the scope is limited, my lord. Yeah.
Pardon?
We have no objection in referring the case for mediation, my lord, but the scope for conciliation is very limited, my lord.
No sense.
Chances there, but limited, my lord. So we are still hopeful, my lord.
Yes, madam.
I have to take instructions, lordship.
You have to take instruction.
Yes.
Can you obtain instruction today?
After 1 week, lordship, fix the matter.
As agreed by learned advocates of both the parties, shall raise the matter on
On 8th August.
8th of August. In the meantime, learned counsel for the respondent shall obtain necessary instruction as to whether the matter can be referred for mediation.
Must.
Item 5.
We have no objection if madam may go to mediation.
Is there any sense or not?
Maybe little bit sense. Maybe.
There is sense.
Yes.
Very little sense, lordship. Very little sense.
Very little sense.
Very little sense.
Then we will fix the matter for hearing.
Maybe fix for hearing, lordship.
Okay. Heard, Mr.
As new.
Learned counsel for the appellant and Mr. Borua.
Jay Sharma,
Jay Sharma for
Visit Borua, lordship. A. Borua, appearing on behalf of A. Borua.
appearing on behalf of
A. Borua.
A. Borua.
A. Borua.
A. Borua. It is submitted at the bar that though the matter is listed for referral to the special mediation drive. That's mediation for the nation. Yeah. There is little chance of the matter being compromised by the parties, and therefore it is contended to list the matter for hearing. Accordingly, it is provided that this shall list the matter for hearing on
Oblige.
Much obliged.
Your lordship, actually, they have brought it by order, lordship. The service is not complete.
It is wrongly come in the, wrong column. I have mentioned the matter for order. Service has not been completed. As per the office note dated 19/7, 2025, respondent number 2 has not received the notice. No, has
3 also, lordship.
3 also.
Okay. Heard Ms. R.D. Mazumdar, learned counsel for the appellant, then also heard Mr.
D. Kakoti, Devaranjan Kakoti.
T. Kakoti, learned counsel for the respondent number 1. It is submitted at the bar that service of respondent number 2 and 3 are yet to be completed.
Lordship, I'll just make a submission. The office note says that the notices by usual process were sent back because the date had expired. So the same notices can again be sent to the Munsif Court, lordship, so that
You have to mention the date there.
mentioned. Yes, that we will do, but the copies that are already there, that may be sent.
So, madam, we will direct you to take step You do the exercise before the rescue.
Okay.
The learned counsel for the appellant submits that she will take step upon the respondent number 2 and 3 again.
By usual process, Lordship,
By
because
usual process. By usual process. Pair is accordingly allowed. Recessal step be taken by usual process within a week from today. Recessal is the matter after 4 weeks.
Yes, Lordship. And this is not the fit case, Lordship, for A because mediation because pay and recovery is there. So without the owner and driver being present, that's hello, Lordship.
31, months of this.
My lord, this is a matter where, my lord, there's an IA is there for a delay condonation of 60 days, my lord. My lord, that delay can be condoned to my understanding. I am for the respondent number 1. It is an accident case, my lord. And then appeal
Appeal is on quantum and it may be placed before the
It is
mediation.
yet to be admitted.
Yes,
my lord. The delay can be condoned.
delay has to be condoned first, you know.
And my lord, on 29th, it may be fixed for, my lord, for the mediation drive, my lord.
29.
Yes, my lord. If not inconvenient, my lord, this one. My lord, I'm sorry, my lord,
Is free order for learned counsel for the applicant and Mr. Everyday learned counsel for the
claimant, my lord, respondent number 1.
respondent number 1. This interlocutory application is preferred to condonation of delay of 60 days in different connected MSC appeal against the judgment and award dated 26/5/2022. Hospital learned member MSCT Kasar in MSC case number 1385 of 2016. Ms. Bortakur submits that.
The appeal is
What
on
is the ground, madam?
Your Lordship, in Peru space number 5, para number 2, Your Lordship. It is due to official delay, Your Lordship. There has been a delay of 60 days, Your Lordship, in filing the appeal.
Sportacle learned counsel for the applicant submits that the appeal could not be deferred in time as the applicant was required to obtain approval from the concerned offices. And that the delay is not intentional and rather the same is circumstantial. And as such, she has contented to condone the same. Mr. Day learned counsel for the respondent number 1 submits that he has no objection in the event of condonation of delay of 60 days in preparing the connected MSC. Para taking note of the submission of learned counsel for both the parties and also considering the explanation forwarded by the learned counsel for the applicant. The support is of the view that the delay of 60 days in preparing the connected MSC appeal is sufficiently explained, and accordingly the same is stands condemned. In view of the order passed in I number so, now the registry will proceed to register the MSC appeal and list the same before the court as soon as practical. Will not fix it. Registry will.
My lord, will indicate a date with that way, my lord, because client will be traveling from Parag Delhi, my lord. So
We have noted that as soon as practical.
for my lord, before the
For
mediation.
listing the matter before the court.
My lord, please. They will,
If it is possible tomorrow.
my lord,
Okay.
please, my lord.
Item 32.
Lordship, here also appeal is on quantum, Your Lordship. So this matter may be referred to mediation, Your Lordship.
So already.
But what is the scope for mediation now? This is because ultimately it is my entitlement to the money. So this appeal has been filed, my lord, by a way of challenging, my lord, that my award that has been passed is not, my lord, in accordance with law. And therefore, my lord, this should be set aside. And the amount that has been fixed should be, my lord, deducted, my lord, reduced. So whether, my lord, that is a fact which can be decided in mediation, my lord. But then I leave it to your lordship, my
Lordship,
lord.
but our appeal is on quantum, Your Lordship.
That is why you please on quantum. So we say, my lord, whatever is the quantum, mediation is between, my lord, those people, my lord, the insurance company on one side and the claimants on the other side. Well, how will they understand, my lord, what is 44% of, my lord, or 1/3 of consortium, or whether, my lord, the father is entitled to be considered to be deceased or not? This is the ground which has been taken, my lord.
So my lord, in my respectful submission, my lord, I think that perhaps, my lord, it is better if it is decided here itself, my lord, because those are certain aspects that cannot be gone into by, my lord, the claimants, because they are very rustic people, my lord, from a remote village, my lord, in Tinsukia district, my lord. That is my submission, my lord, subject to what your lordship, my lord, says, my lord.
Okay, if there is a least possibility of
Settlement, my
any
lord.
positive outcome, then we'll list the matter for hearing here.
Yes, my lord.
Or Ms. P. Thakur, learned counsel for the appellant, and Mr. G. Chaudhary, learned counsel for the respondent. Though the matter is listed under the column, so it is submitted at the bar that there is no chance of any positive outcome, even if the matter is referred for mediation. Mediation. And as such, the matter may be listed for hearing before the court. Accordingly, it is provided that the SSL list the matter for hearing on
Let it be after 15th of August, my lord.
15th.
After 15th of August.
28 of
28 August, my lord.
That's for admission. Item number 6, Spartan matter.
The last occasion, your lordship has asked why lesser amount has been paid, my lord.
So, Soma, any
Lordship, I have received instruction insofar as why the lesser amount is paid. May I place it before Lordship? And this is as per rule, Lordship. There is an OM, Lordship. So, as per rule, that after 7 years, at a particular period of time, it has been reduced to 50% to 30%. And that there is an OM also. So, this instruction specifies that, Lordship. According to the OM communicated by the secretary so and so, dated so and so, the provisional family pension has been received by the spouse, that is 50% of the basic pay of the incumbent till April 2025. Rupees 22 so and so. Thereafter, as per the pension rule, the basic pay of the provisional family pension has been reduced up to 30%, that is 13,400. And there is an office memorandum also that I have placed before your lordship.
Provision to give
Itu OM আছে। মই দি আছো আপোনাক দি আছো। Provision আছে। সেইটো 17 অক্টোবৰ 2007 সেইটো এটা পিৰিয়ডত ৰিডিউচ হৈ যায় Lordship, finally peruse that second page, Lordship. That Roman 3, compassion and family pension, pension sanctioned to the family of the government servant who died while in service or after, so and so, so and so.
They have not provided compassionate family pension. It is not a compassionate family pension.
Lordship. Now, Lordship, if your Lordship, last but the second paragraph, Lordship, on attending the date of deemed superannuation, the compassion family pension will be converted into normal family pension. The normal family pension shall be fixed at 50% of the compassion family pension for the from the date of deemed superannuation till 67 years of age.
Mr. Sharma, this is provisional pension.
The provisional pension also according to this rule only. That according to their communication. Lordship, that communication letter they have written. Lordship, kindly submission of present status report in connection with so and so. With reference to the subject cited above, I have the honor to inform you that Pradeep Kumar Borwa, inspecting auditor, was retired on 31/12/2017 and expired on 29/9/2019. The compliance of the order of the Honorable High Court, in compliance of the order of the Guwahati High Court, in communication number so and so, the month wise provisional pension of the incumbent has been released to the spouse till June 2025. That, madam, according to the OM communicated by the secretary, that OM that I have placed before Lordship, dated so and so, the provisional family pension has been received by the spouse, that is 50% of the basic pay of the incumbent till April 2025, rupees 22,328 thereafter. Thereafter, as per the provision rules, the basic pay of the provisional family pension has been reduced up to 30%, that is 13,400, and other allowances. So this they have communicated Lordship.
No, whether there is any reference about the provisional pension in this OM.
In this OM, otherwise in this OM, that the word provisional pension is not stated here. But according to this, they have revised that, Lordship. And otherwise also, Lordship, in this matter, that pleadings has already been completed.
Pardon?
Otherwise also, pleadings are
That's all
complete.
right, we'll hear the matter, but whether you tell me whether this OM will be applicable in the case of the provisional pension.
That I have not come across any.
And besides, the matter is sub judice before this court.
Lordship.
And my lord, they have stopped my pension, but the honorable court has directed, my lord, on 3-4 occasions, my lord. After direction, they have released family matter.
Kindly come to page number 3 of the OM, Lordship. Family pension on provisional basis, Lordship, the third page. Family pension on provisional basis to the family of the state employees appointed on or after so and so and covered by NPS so and so who die in harness till so and so shall be governed by the PNPG department OM number so and so. However, the government servant appointed under new defined contributory system and dies on or after so and so shall be governed provisionally by the provisions as described in clause 1(3)(a) of this guideline. And in terms of para 5.9 of the Finance Establishment Department notification number so and so. So this has been specified, Lordship, in regard to the provisional pension also. These guidelines has been issued in terms of the Finance Establishment notification dated so and so. Amendments to the relevant rules so and so shall be done after the following the process. So there is a problem. This is for the provisional pension also they have specified.
He was under the NPS or?
No, my lord, they have to clarify, my lord. I am not NPS, my lord. My appointment was earlier, my lord.
In the year?
I am telling you, my lord.
Lordship, here the regularization itself is in dispute, Lordship. Because
I have joined the inspecting auditor on 24/1/1994.
94.
24/1 January 94.
His appointment itself is an ad hoc and never been regularized. That we have already specified in our.
Then they whether I am in NPS or RDR provisional, they have to clarify their stand.
Mr. Sharma, it's a provision number 2.
Lordship.
In page number 3 of the OM.
Lordship. That
is in case of NPS.
Family pension. Lordship, here is the case. Lordship.
They have also not furnished my.
Lordship, here is the case. May I place it before Lordship? The service of the petitioner has never been regularized. He was all along been on ad hoc basis. This provisional pension has been given in compliance to the order of this honorable court. There is no regularization of service. Hence, Lordship is not entitled for according to
Who is responsible for the same?
Lordship.
In this regard, my lord, various orders has been placed. They have also asked to place the order of regulation. In 3-4 earlier occasions, this honorable court has passed many orders, my lord. They are here, my lord, but they have not passed any order for regulation.
Regulation that we have already specified in that. The Lordship will fix the matter on hearing for admission hearing, Lordship, because finance also equally required, and the government also, because we as a department, administrative department cannot regularize unless there is a sanction from the PPG department. That particular point we have already specified in our affidavit, Lordship. If a Lordship, there is our affidavit, Lordship. There are two affidavits filed by the department, Lordship, yeah.
No.
My lord, let them
you-
clear at first whether lesser amount has been
you-
paid or
you
not.
Tell me, having been appointed in the year 1994,
Lordship.
how can the person continue till his retirement as on ad hoc basis? Under what provision of law?
There is a time to time extension of that ad hoc appointment.
No, is there any provision that service can be extended till his retirement on ad hoc basis?
There is an order for till regularization service has been extended. That also I have an in my report.
For a moment, may I take your Lordship to our affidavit, page number 91.
No, if the matter is not ready for hearing, then we will not hear it.
Lordship may fix the matter for admission hearing on any date, Lordship.
But you continue to pay the pension in the earlier rate.
Provisional pension,
Earlier, yes, provisional.
provisional pension we have been paying, Lordship.
But my lord, they have right now they have reduced to 13%, my lord.
That-
Thereafter
that-
also
that-
they have reduced,
that
my
part
lord,
will clarify.
without any
Lordship,
provision of law, my lord.
insofar as the payment of family pension is concerned, Lordship may fix next week.
And the
I
OM is
will
in the
come
year
with the
17, my
clarification.
lord. They have earlier not pointed
I
out this
will-
before his honorable
I'll-
court.
let
That
me-
OM is in the year 2017, OM.
Let me submit.
17, OM.
Lordship, insofar as the payment of family provisional pension is concerned, Lordship may fix next week, Lordship. I will come with the clarification whether this provisional pension is applicable or not, and insofar as that ad hoc appointment part, insofar as the provisional pension is concerned. And on for regular pension, Lordship, buildings are there, Lordship, we will come with the.
No, you continue to make payment of the provisional pension at the earlier rate.
Before that, Lordship,
Obliged.
allow one date, Lordship, let me clarify this provisional
no.
part.
No. You pay the provisional pension at the earlier rate.
Because as per OM, it has been specified that this is applicable for the provisional basis also. Family pension on provisional basis.
Or Mr. D. Bora, learned counsel for the petitioner, and Mr. E. N. Sharma, learned standing counsel for the education within bracket elementary department, appearing for the respondent number 1, EN 5, and Mr. C. Sharma, C. Bora, learned standing counsel for the respondent number 7, and Madam Kokon for respondent number 2 and 3 and 2 and 6, and Mr. Soliha for respondent number 8. Respondent number 8. Mr. Sharma, learned standing counsel for the respondent number 1, 3, 4, and 5. Comma, person to direction of this court dated 16/6/2025 has produced one communication issued by the district elementary education officer Sipsagar, addressed to the director elementary education Kailipara, Guwahati. Stating the grounds for reducing the provisional family pension from 50% to 50% to 30%. 50% to 30%. On the basis of one office memorandum dated 31st of October 2007. But Mr. Soma fails to persuade this court as to whether this office memorandum will be applicable in the case of the present petitioner or not. Under such circumstances, it is provided that the petitioner shall be paid the provisional pension at the rate of 50%. 50% of the basic pay of the incumbent till further order. Till further order. And raises a list the matter for hearing on. But
Lordship may fix it. On 28 August. 28 August.
Or let,
21st August. And Lordship, here the.
My lord, 50% basic pay along with other admissible benefits.
yes, along with other admissible allowances.
Right.
Other allowances as admissible under the law.
They have not furnished me the copy. Let them furnish.
Okay.
I will right away. I will give. Lordship, may kindly show the name of the standing council finance in the cause list because. Achha. Because there stand also.
So item 7.
Obliged.
Lordship, provisional insofar as the provisional presence is concerned, that 50% of the basic is given Lordship. Other allowances and all that is on a regular pension. So that part, Lordship may kindly that.
As admissible under the law. If it is not admissible under the law, then no.
Add as many on the Lordship.
Item 7.
My lord, I have filed my affidavit yesterday.
When?
Yesterday.
Today?
Yesterday.
Yesterday.
With a
So it's
copy.
not placed on record.
My lord,
Yesterday.
So let it be on another day.
my lord, then in the meantime, I may file our affidavit in opposition on some factual aspect. May it come on 5th of August, my lord.
5th of August. Okay. As agreed by learned advocates of both sides, VSSL is the matter on 5th of August. Along with the affidavit filed by learned counsel for the petition.
Obliged.
Number 8.
Please, Your Lordship.
You are for the petitioner.
Lordship.
Who is for the respondent?
None appear to the respondent, Lordship. Service has been completed. Lordship, the CRP has been filed against the order dated 5/2025, passed by the Civil Judge General Division Baksha. In media case number 37/2024, entitled execution case number 5/2018, Lordship.
Whether notice was served upon the respondent?
Lordship,
When?
notices are served. What happened, Lordship? The predecessor of the petitioner filed a title suit against one Hori Gwala, the original defendant, Lordship, before the Municipal Baksha. There was numbered title suit number 302/2013. In the said title suit, notices are served upon the original defendant. Defendant appeared and filed in the WS along with a counterclaim. During the pendency of the suit, Lordship, the original defendant died, and in his place is legal representative were substituted, and notice was sent to the substituted legal representative also. But they did not appear. As a result, the suit proceeded ex parte. And the suit was decreed by judgment and decree dated 23/10/2017, Lordship. Thereafter, the petitioner has filed an execution case, Lordship.
Where is the impugned order?
Impugned order is at page 85, Lordship.
Page number
85. The petition was filed at title execution lordship. That was numbered as title execution case number 5 2028. Sorry, 2018 lordship. The notices are served upon the judgment debtor, but they did not appear. Then your lordship in 2018, the present respondent filed a petition under order 9, rule 13 and order 1, rule 10 sub rule 2, read it section 151 for setting aside the ex parte order and to add her as a party defendant. That was also dismissed, lordship. Thereafter, the respondent filed a misappeal. That misappeal was also dismissed. Then the respondent filed a petition before the executing court under order 21, rule 97, 99 and 101 lordship after a gap of 7 years, 12 days.
What wrong with this order?
Lordship, this petition was filed after after a gap of 7 years, Lordship, that was barred by the law of limitation. No condemnation petition was accommodated with this.
No, the executing court has allowed her to adduce evidence as per order 21, rule 97, 99, and 101 of the CPC.
Lordship. That was barred by the law of limitation, Lordship.
How?
The limitation period for filing any application or no specific time limit is fixed. It is three years as per Article 137 of Limitation Act.
When the execution proceeding was started?
18, Lordship.
2000?
2018. And
18.
18. And as per her averment, she got the knowledge on 1/12/2018.
Where it is stated?
In her petition, Lordship,
Page number?
at page 71, Lordship. Operative part, page 76, Lordship. Paraport.
Yes.
The pro forma opposite party number 2 within bracket 3, Lachit Goala, who is a brother of the present petitioner stranger, came on 1/12/2018 and made the petitioner stranger. The pro forma opposite party stated the petitioner stranger that he received a notice on 4/10/2018. The petitioner stranger could know that Learned Court had already passed a judgment and decree on 23/10/2017 in title suit number 302 of 2013. So she got the notice on 1/12/2018, Lordship. And she has filed this petition under order 21 in 5/11/2014 after a gap of 7 years without any condemnation petition, Lordship. And maximum period of limitation is 3 years as per Article 137 of Limitation Act. And trial court has also rejected her petition under Order 1, Rule 10 to Lordship, because she could not substantiate that she is the legal hire of the original defendant in the trial court.
Whether you have filed any objection against this petition?
We have filed our objection, Lordship.
Where is that objection petition?
The objection I have to annex here, Lordship. But that is
The copy with you.
Lordship.
You have the copy with you.
Yes, Lordship, office copy was there. It is not certified, Lordship, office copy.
You bring it on record by filing an additional affidavit.
Lordship, I will bring it on record, Lordship.
Heard Mr. M. Rana, learned counsel for the petitioner. List the matter on when? After 1 week.
After 1 week, Lordship.
Right.
First week of August.
So as to enable Mr. Rana to bring on record the objection filed by the petitioner in the application,
Media case number
in the
37.
petition number 821 of 2024, dated 5/11/2024,
That was registered as media case number 37 of 24.
upon which media case number 37 of 2024 in title execution case number 5 of 2018 came to be registered. Listen. 6.
Till then, Lordship, the impugn order may be stayed, Lordship.
No, no.
Opposition of the impugn
No.
order. Till the next date, Lordship.
No. You file the objection petition, then we will see.
That's
I think for hearing under order 41. Item number 9.
May it please your lordship. The appellants are the plaintiffs, lordship. Lordship, and this is a
Appellants
suit-
are from?
plaintiffs, lordship, sued to us
What's-
for specific performance of contract, lordship. Trial court decreed the suit, but first appellate court, lordship, reversed that finding by holding that the suit of there is no readiness and willingness on the part of the plaintiffs, lordship. Lordship, kindly see page 6, plaint, lordship. In this case, what happened, lordship, the plaintiffs and the defendants were friends, lordship. So he allowed the plaintiffs to look over the property, lordship, in his absence, as because the defendant was a Maulavi, lordship, and he was engaged in a masjid in Dimapur, lordship.
The plaintiff is at page number
6, lordship, annexure 1. In para 2, we have stated that, lordship, that for his urgent need of money, the defendant intended to sell the suit land, but as he was engaged in works outside Assam, he appointed the plaintiffs as his lawful attorneys by registered power of attorney deed number so-and-so, empowering them to alienate the property to anybody by fixing consideration and by executing deed of sale or mortgage or lease, etc., for and on his behalf. Then, lordship, para 3, that sometimes after the execution of the power of attorney deed number so-and-so, the plaintiffs themselves desired to purchase the land at market price, and after negotiations, the defendant agreed to sell the land to them at a consideration of 8,40,000 and by executing a written Bayanapatra on 18/10/2010, lordship. He received an amount of 2,50,000 from the plaintiffs as part payment of the total consideration, promising to execute the registered sale deed in their favor by receiving the balance consideration and deliver possession of the land by shifting his houses elsewhere. Thereafter, lordship, as prior permission from government for sale and purchase of any landed property is required, the plaintiffs asked the defendant to accompany them for filing the petition before the authority concerned, but the defendant sought some time as he had to proceed to his place of work urgently. That thereafter the defendant came to his residence occasionally, as he was lordship working outside. So when he came, but he willingly avoided meeting the plaintiffs, and on pretext one another, he delayed the matter of signing the petition and obtaining the sale permission to complete the performance of the sale contract by executing the registered deed in favor of the plaintiffs. That by this time the value of the land has gone up high, and the plaintiffs came to learn that the defendant was secretly negotiating with others to sell the suit land at higher price, suppressing the subsisting sale contract made with the plaintiffs. Now, lordship, these are same, lordship, about my notice and all this. Para 8, lordship, that the sale contract made by the defendant with the plaintiffs on 18/10/10 is valid, subsisting, binding upon parties and enforceable in law. By receiving 2,50,000 as part payment of the total consideration, the defendant has performed a part of the contract, and he is bound to perform the rest part by executing registered sale deed in respect of the suit land in favor of the plaintiffs by obtaining sale permission, by receiving the balance amount of consideration, and by delivering vacant possession of the land to them. The plaintiffs on their part have performed a major part of the contract by paying a big amount to the defendant as part payment and by arranging the balance consideration. So I have clearly stated that the balance consideration already I have arranged, Lordship. And they are always willing and ready to perform the remaining part of the sale contract. So readiness, willingness, Lordship, pleading is there by the plaintiff. They have not violated any term of the contract and there is no negligence from their side to perform their part of the contract. On these Lordship pleadings, the plaintiff suit was filed, praying for specific performance of the sale deed on the basis of that Bainapatra 1810-2010, Lordship. Learned trial court, Lordship, formulated some issues. Defendant denied about the execution of the sale deed and deed of agreement. Page 29 are the issues, Lordship.
Yes.
Whether the suit is maintainable, barred by limitation, and the 3, 4, 5, 6 were together discussed by the learned trial court. These are page 30. Issue number 3, 4, 5, 6. Maintainability in my favor, Lordship. The suit is maintainable as held by the learned trial court in issue number 1. Then issue number 3, 4, 5, 6. Those issues are discussed together. The plaintiffs, in order to prove their case, had examined Sri Shanti Uddin Sheikh, PW1, who is also one of the plaintiffs, and he had specifically deposed that the plaintiffs and the defendant Sri Abdus Samad entered into an agreement in respect of the suit land, and it was agreed that the plaintiffs would purchase the land upon sale consideration of 8,40,000, and out of the aforesaid amount, an amount of rupees 2,50,000 was paid to the defendant. The PW1 had produced the said deed of agreement as of sale dated 18-10-2010, which is marked as Exhibit 2. The PW1 had also identified the signature of the defendant, Sri Abdul Samad, upon the Exhibit 2, and the same is marked as Exhibit 2122. The plaintiffs had also examined the writer Mohori of the Exhibit 2, namely Sri Hamid Ali, PW2. And he had also specifically deposed that he drafted out the Exhibit 2, and thereafter Sri Abdul Samad, defendant.
So, madam, where is the finding of learned
First
trial
appellate.
court on issue number?
456, Lordship.
Yes.
Readiness and willingness, Lordship, the learned first appellate court.
No, trial court.
Trial court, Lordship. After all discussions in para 17, it held that the plaintiffs were ready and willing. Para 16 also, your Lordship can see the plaintiffs have specifically pleaded that they were always ready and willing to pay the balance sale consideration, but the defendant refused. The PW1 has specifically deposed that the plaintiffs were always ready and willing to perform their part of the contract, but the defendant neglected to execute the registered sale deed, and so the plaintiff issued a notice dated 23/9/2013. But the said notice was refused to be.
Which paragraph you were reading?
Para 16, Lordship, page
16.
33.
Okay.
But the defendant neglected to execute the registered sale deed, and so the plaintiffs issued a notice dated 23/9/2013. But the said notice was refused by the to be accepted by the defendant. Hence the suit. The plaintiff PW1 had produced the notice, which was sent through registered post. An envelope of the registered post containing the notice is marked as Exhibit 3. The perusal of the Exhibit 3 reveals that the same is addressed to the defendant, and it contains an endorsement of the postal peon that the same was refused. The plaintiff PW1 was not at all cross-examined in this regard, and moreover, there is nothing on record to doubt or disbelieve the plaintiff PW1 in this regard. As such, it is held that the plaintiff issued the notice to the defendant to perform his part of the contract, but the defendant refused to accept the same. In view of the above discussions, it is held that the plaintiffs were ready and willing to perform their part of the contract, but the defendant neglected to perform his part of the contract. But
Then
first
the
appellate
finding of the appellate court?
First appellate court held that, Lordship, we are not ready and willing. That is,
In
Lordship.
which paragraph it was discussed?
Lordship. page 61, Lordship, paragraph 24. Preliminary decisions were discussed, Lordship. Now, on the basis of, I have not submitted the income certificate, I have not shown the income of the one of the plaintiff is an advocate, Lordship. So on the discussions of these decisions, Lordship, it held in paragraph, the long discussions, Lordship. Paragraph 48, Lordship, page 81. On testing the above said law on the anvil of present factual scenario. Your Lordship got it. Paragraph 48, page 81.
Yes.
On testing the above said law on the anvil of present factual scenario, as there is a great delay in filing the suit, this has put a deep dent on plaintiff's conduct in respect of his readiness and willingness. In the instant case, the suit for specific performance of the contract was filed on 13/11/2013. The agreement to sell is dated 18/10/2010. Nothing prevented the plaintiffs to approach the learned trial court expeditiously. However, for the reasons best known to the plaintiffs, the suit was filed only in the year 2013. It is also noteworthy to mention that the plaintiffs had never addressed any notice to a defendant except the one on 23/9/13 to perform agreement dated 18/10/2010, but merely because of creation of some evidence at the later point of time by issuing a legal notice alone is not sufficient to prove his readiness and willingness. Suit for specific performance need not be decreed merely because it is filed within the period of limitation of 3 years. My notice is, Lordship, within the period of limitation, and the suit was filed within 3 years, Lordship. The fact that limitation is 3 years does not mean that a purchaser plaintiff can wait for 1 or 2 years to file a suit and obtain specific performance. The 3-year period is intended to assist the purchaser plaintiff in special cases, as for example, where the major part of the consideration has been paid to the seller defendant and possession has been delivered in part performance, where equity shifts in favor of the purchaser plaintiffs. In this case, Lordship, the three are friends, Lordship. There was a power of attorney executed in favor of these two persons to look after the property, Lordship. So there was no case initiated by the plaintiffs at the earliest, Lordship. There was a compromise in between them that the sale deed will be executed, Lordship. But when he completely denied after 2 years, as because, Lordship, land price by that time increased, Lordship. So they are bound to file the case, Lordship. And this First Appellate Court, Lordship, on the basis of this, that there is no readiness and willingness, there is a specific pleading, Lordship. Supreme Court, Lordship, again and again saying if there is a specific pleading about readiness and willingness, then the duty on the defendant to perform his part, Lordship. And we always, the plaintiffs always avoid in the plaint that he is ready.
Even if the plea is there in the plaint,
Lordship.
Is it not the requirement that has to be established by adducing evidence?
Lordship, I have adduced all the evidences that notice and all by PW2 also adduce evidence saying that this exhibit was, and even Lordship DW, he admitted in his cross that he has already received 2,50,000. The clear finding by the trial court in this aspect, Lordship. The DW, though denied in his written statement, later on in his evidence admitted that the deed was executed in favor of the plaintiffs and he received 2,50,000 for that sale transaction, Lordship. Paragraph 12, Lordship, page 31. On the contrary, the defendant, Sri Abdul Samad, had admitted about the aforesaid agreement in his deposition. Everything was admitted, Lordship. The defendant, Sri Abdul Samad, DW1, had examined himself, and in his examination in chief, he had stated that in the month of August 2010, he entered into a written agreement. Page 31, Lordship. Paragraph 12, Lordship. He entered into a written agreement of the sale with the plaintiffs and not on 18/10/2010. The DW1 Sri Abdul Samad further admitted that the sale consideration for the suit land was fixed at rupees 8,40,000, and out of the aforesaid amount, the plaintiffs paid only rupees 1,10,000 and not rupees 2,50,000 as agreed. So a part of payment he received that he admitted. A deed of agreement execution also he admitted, Lordship. The DW1 Sri Abdul Samad further stated in his examination in chief that he again approached the plaintiff Sri Shantiuddin Sheikh after 2-3 days for another rupees 90,000, but the plaintiffs did not pay. Hence, the said agreement of sale stood cancelled. It would be pertinent to mention herein that the DW1 Sri Abdul Samad had, however, admitted nearly all the allegations of the plaintiff during his cross-examination, and he had deposed contrary to what he had stated in his examination in chief. The DW1 Sri Abdul Samad had admitted in his cross-examination that he agreed to sell the suit land to the plaintiffs and also admitted that the sale consideration was fixed at rupees 8,40,000, and he had also admitted that he received rupees 2,50,000 from the plaintiffs as advance amount. It is seen from the specific admissions made by the defendant Sri Abdul Samad in his cross-examination that he had agreed to sell the suit land to the plaintiffs and that the sale consideration was fixed at rupees 8,40,000, and out of the aforesaid sale consideration, he had received rupees 2,50,000 as advance. As such, it is held that the defendant Sri Abdul Samad agreed to sell the suit land to the plaintiff, and he had received rupees so and so as advance amount out of the total consideration amount. So everything was admitted, Lordship. So it is not necessary to prove each and every fact, but Lordship, deed of execution admitted, sale consideration amount, advance amount was also admitted by the defendant. But later on, Lordship, due to the increase of the rate of the sale price, Lordship, the defendant refused to, Lordship, execute the sale deed. Paragraph 13, Lordship. Moreover, the defendant's witness, Sri Ghulam Nabi Mia DW2, had specifically admitted in his cross-examination that he was present when the plaintiff and the defendant entered into the written agreement to sell the suit land for sale consideration of rupees 8,40,000. The DW2, the Sri Ghulam Nabi Mia, further identified the said agreement as Exhibit 2. His own witness, Lordship, admitting my case, Lordship. DW2 further stated that the defendant executed the aforesaid agreement of sale. It is clearly proved from the above that the defendant entered into a written agreement to sell the suit land, and Exhibit 2 is the said agreement. In view of the specific admissions made by the defendant and his witness, and also in the light of the evidence of the plaintiff, it is held that the defendant had executed the Exhibit 2 and he had agreed to sell the suit land for total consideration of rupees 8,40,000. And out of the aforesaid amount, he received to him. Lordship, it's a decree of reversal. Lordship, kindly admit this appeal. And Lordship, I want to purchase the land, and in the year 2010, we have already, Lordship, reduced the advance amount. And in the meantime, Lordship, we are agreed to, Lordship, purchase the land. So we are contesting, Lordship, readiness and willingness proved from this also, Lordship.
Okay, we'll examine the appellate court judgment again.
Lordship, in the
Call the
meantime,
order.
in the case, what happened, Lordship, suit of the plaintiffs was dismissed, and thereafter, Lordship, a money decree was the advance, there is a direction to return the advance amount, Lordship. So we have filed one stay application for stay of the judgment of the first appellate court. And there is an injunction application also, so that they cannot sell the suit land to some third party and create multiplicity of suits, Lordship, during the pendency of the regular second appeal, Lordship.
Okay, we will see.
Lordship. And both the applications are also pending, Lordship. And we have heard that in the meantime, Lordship, they have already executed title execution application, Lordship. Notice was also served.
Okay, we'll
So for that only, I have mentioned this matter, Lordship, for list.
Okay.
Obliged, Lordship.
Item number 10 for orders.
Mayor, please, Lordship, this matter was supposed to come for hearing. This was the last order. I filed an early hearing application that was allowed. So today it has come for order, so it may fix for the date for hearing.
No, on the other day, one party.
He was there, but he left for another court, so.
Okay. Yes, agreed by learned advocates of both the parties, raises and lays the matter for hearing on 21.
28.
Obliged.
Item number 33.
None appears for the petitioner on call.
Made with your lordship. In this case, lordship, my second suit was returned, lordship, for as not maintainable, lordship. Annexure, and as this plaint was returned, lordship, as not maintainable, dismissed as not maintainable, so we have to prefer a regular first appeal. And in preferring the regular first appeal, there is a delay of lordship 240 days. In this case, notice was already issued. The respondent not yet filed any objection, lordship. Though it's a regular first appeal.
My lord, may kindly come to office note dated 19/7/2025.
Yes.
No, it says that this objection was to be filed on behalf of respondent number 2, 3, and 4, which has not been filed. And fresh steps were to be taken again upon respondent number 1, that has not been taken. And the appellants were supposed to file one substitution petition with regard to the substitution of the legal years of respondent number 12.
Lordship, respondent number 12, we will pray for striking out the name as is a pro forma, lordship. And respondent number
Whether
1.
any order was passed?
No, lordship. Today itself we can pray, lordship. Thereafter, today it has listed, lordship. So for 12, we will pray for striking out the name of pro forma respondent number 12, lordship.
And in respect of 1?
1, lordship, the other brother and sisters are represented by my learned friend, lordship. He can appear for him also, Amer Ali.
But my instruction is that the respondent number 1 is yet to receive any notice, my lord. He was in jail, my lord. That is why he did not receive any notice, my lord. But now he has been discharged. So, but
his own brother, lordship, he can appear for him also, lordship.
And my lord, since on the last occasion, my lord, the honorable court directed them to take fresh steps, my lord. So let them take fresh steps, my lord, upon respondent number 1. And in the meantime, my lord.
No, perhaps you have been directed to obtain instruction as to whether you can enter appearance on his behalf.
That order does not reflect that, one.
No, there was no such direction, lordship. Just I am, lordship, submitting before your lordship that respondent number 1 being, whether there is any such order, I am also not sure, lordship. If lordship, respondent number 1 is son of Monser Ali and he is appearing for all the legal heirs of Monser Ali except this Amer Ali.
I'll take that instruction, my lord, whether I can appear on behalf of the respondent number 1, my lord. In the meantime, my lord, lordship may give us a short time, my lord, to file objection on behalf of the other respondents.
Already 2-3 dates were given.
Since 30 date to be completed, my lord. So, my lord, next date, my lord, if I can appear on behalf of the respondent number 1 as well, my lord, I can file comprehensive written objection on behalf of the all the respondents, my lord.
And the impugn order itself reflects that your lordship has already given a judgment in the similar situation, lordship. In one RFA, on the very first day, your lordship allowed the RFA. In that case, there was no condonation. I'll bring that judgment also, your lordship. In this case, what happened, lordship, applying the principle of res judicata, lordship, my second suit was rejected. Against that, I am before your lordship. Though it's a RFA, lordship, my plaint was rejected, lordship.
In which matter you were referring to?
Lordship, that one RFA is there. I appeared before your lordship, and your lordship on the very first day, your lordship has allowed this matter. I'll bring that order, Lordship, on next date. A short date may be given next week, any date, Lordship. In the meantime, if he wants to file objection, he can file.
So today learned counsel for the applicant. And Mr. Singh for respondent numbers.
No, nothing, no.
Respondent number 2.
No.
5 and 6. Respondent number 5 and 6 and Mr. S. Das learned
2, 3 and
for the respondent number 2, 3 and 4. 2, 3 and 4. Ms. Chaudhary, learned counsel for the applicant submits that the name of respondent number, performer respondent number 12 may be struck off from the array of his application since he has already suffered demise. There is accordingly allowed at the cost and risks of the applicant, the name of the performer respondent number 12 is struck off from the array of his application. Office note dated 19/7/2025 indicates that press received upon respondent number 1 has not yet been taken. Ms. Chaudhary submits that respondent number 1 is the brother of respondent number 2, 3 and 4.
Yes, Lordship.
2, 3 and 4. And the learned counsel appearing for the respondent number 2, 3 and 4 may represent him. But Mr. S. thus learned counsel for the respondent number 2, 3 and 4 submits that he will obtain instruction in this regard, and he also pays for granting him some time to file objection in this application. There is accordingly allowed recessal is the method on.
Next week, Lordship, any date? Already my suit was rejected, Lordship.
8 August.
8 August.
My lord.
Obliged, Lordship.
My lord.
Schedule for hearing 13 and 14 for 13.
Lordship, I pray for some accommodation. Your Lordship, can this matter be taken up at 2?
Today,
Yes, Your Lordship.
Only, my lord, appellant side, my lord, already hard lawsuit, only 1 point, my lord, single point was, my lord, remaining to be hard lawsuit on. My
that is
lord,
the point.
my lord, the husband's, my lord, income lawsuit, that was not, my lord, no document was exhibited lawsuit.
Pardon?
My lord, the husband's income lawsuit. Here in the, my lord, case was, my lord, the deceased was, my lord, non-earning member lawsuit, white lawsuit. The husband's income was taken into consideration lordship, and 1/3 of husband's income lordship, claimant number 1, husband is claimant number 1, my lord. During deposition, my lord, under section 165 evidence act lordship, court learned tribunal put some questions lordship. During questions, my lord, it was revealed that the husband's income was, my lord, 51,000 lordship per month. My lord, she was salaried, my lord. My lord, he paid, my lord, income tax rupees 13,000, my lord, per annum lordship. Now, on the basis of that, my lord, the income was, my lord, assessed lordship by the learned tribunal, my lord, and 1/3 of the husband was taken into consideration, my lord. That part, my lord, considered by the insurance, my lord, on the earlier appraisal lordship.
Lordship,
Now, only remaining part is, my lord,
conducting counsel is not present, Your Lordship, so I pray if it can be taken up at 2, or it may be passed over for the time being, Your Lordship. He is on the way.
Okay. Time being.
Lordship. Obliged.
Let him come.
lost.
Number 20.
Mr. Kati, who is for the respondent?
Respondent is J. Lusker advocate, my lord. I have not seen.
N.S. Lusker.
Yes, sir.
N.S. Lusker. Is he
J.
present in the court?
J. Lusker did not see today. Today I have not seen him.
You have not seen him?
No.
This
Otherwise,
is
it is a matter of 2015 matter. 2015 matter.
Yes, yes.
Very old pending. Can we try at 2, my lord? At 2.
Today.
Yes, my lord.
Okay, all right. Okay.
Public.
Let's say item 21, in this particular case, let's say, as per information received, there is a title suit pending between the parties. That is, let's say, title suit number 116 of 19, filed by the appellant herein, in the same properties pending in the court of civil justice. Let's say, I want to take the instruction regarding the fate of the case. Let's say.
In respect of the same plot of land.
Let's say, there is a, let's say, according to him, let's say, he has purchased 3 copies of land from defendant number 2 and 3 in the title suit filed by him. That suit has been filed stating that he has purchased the land from defendant number 2 and 3, 3 copies of land. According to me, I have purchased 1 kata of land from other person, Prabodh Haloy. I purchased 1 kata of land Prabodh Haloy by registered sale in 1986. And thereafter, land has been mutated and patta has been issued in my favor. And I'm occupation of the land, 1 kata land purchased from Prabodh Haloy. And remaining 16 less I am occupying from the mother of the vendor of the present respondent number, dependent respondent number 1. There is an agreement for sale for 16 lessons of land. Accordingly, sale permission was also obtained from the authority. Thereafter, sale deed was not executed and Gauridas has died. And thereafter, the son of Gauridas has sold 3 katas of land without any occupation. He has sold the land to the defendant number 1. That is the fact of the case. And they have not challenged the land purchased by the Prabodh from the by the appellant from Prabodh Haloy in the suit filed by them. If Lordship hear the matter, Lordship, I cannot complete because I have to take the instruction regarding the suit filed by the present appellant. That is title suit number. Any date Lordship may fix because 116 of 2019.
Mr. Ali?
My lord, this suit filed, my lord, they're totally different land, my lord. Their plea, my lord, in the suit, my lord, that decree will not be, my lord, decree will not, my lord, apply in their case. So, my lord, they file different suit, my lord. And in the suit, my lord, their claim, my lord, regarding 1 kata of land purchased from another, my lord, owner.
And
out of total, my lord, 4 kata 10 lesser, my lord. My lord, there is 2 owner, my lord. I have purchased from the owner who have, my lord, 3 katas. And he purchased from the owner who had, my lord, 1 kata 10 lesser. So schedule is different, everything is different. After decree, my lord, he filed this suit.
Look, see, they are the party in the title number 116 of 2019. So I want to know the fate of the case from the advocate appearing in the case.
Lordship kindly see paragraph 6, my lord, of this paragraph 4. Is plain, my lord. This is my subsequent suit, my lord.
Anyway, let him obtain instruction, Mr. Ali. Let him obtain instruction, we'll fix a sort.
And case is pending for evidence, my lord, as per my information, my lord.
Only they are the party in the suit also. So I want to take the instruction. Any date, Lordship may fix.
Heard Mr. S.K. Goswami, learned counsel for the applicant, appellant, and Mr. R. Ali for the respondent. Mr. Goswami, learned counsel for the appellant, submits that another case being title suit number
Title suit number 116 of 2019.
This is the claim.
116 of 2019.
116 of 2019 is pending between the same parties. And he will obtain necessary instruction regarding the present status of the aforementioned title suit. And he prays for listing the matter after a week. Here is accordingly allowed. Rest is the matter on
19th August,
sorted.
14th August.
Ali, you can take it.
Lordship. Okay.
So we will resume after 5 minutes.
Matter numbers 22 and 23.
Wait, please, loss. My lord, both the party filed my lord succession petition, my lord, before the trial court. My lord, in respect of the my lord debt security, my lord, left by the my lord deceased person, my lord, who was working, my lord, in the railway department, my lord. The both petition, my lord, dispose of together, my lord. The petitioner claimed that, my lord, the deceased person is her brother, my lord, died unmarried, my lord, and my lord leaving behind his, my lord, siblings, my lord. The respondent, my lord, claimed that, my lord, let, my lord, the deceased person, my lord, died married, my lord, leaving behind his wife and, my lord, 2 sons, my lord. This is the, my lord, disputed, my lord, and, my lord, both the, my lord, petitioner dispose of together, my lord. Of judgment, my lord, in page number, my lord, kindly see 34, my lord, started from 34, my lord. Here, my lord, only, my lord, one issue has been decided, my lord. The issue, my lord, in page number, my lord, 42, my lord. One.
Page number?
Page number 42, my lord. My lord, middle portion, my lord. Started from, my lord, the paragraph. Third column, my lord. Whether I consider the application of Srimati, my lord, so and so, and her sons, my lord.
Page number 42.
42, my lord. Third line, my lord, started from whether I consider, my lord. Whether I consider the application of Srimati so and so and her sons, my lord, or application of Srimati, my lord, the petitioner, my lord, Ranu Sanswa, my lord, and her sibling, my lord. The moot point of determination in order to arrive at just decision is as to whether Srimati Mona Lisa Sanswa was the wife of Kalyan Sanswa since disease. If the question is answered in affirmative, my lord, the case of, my lord, Srimati Ranu Sanswa and 3 others will fall apart, my lord. And if the question is answered in negative, my lord, the case of the, my lord, Mona Lisa Sanswa, my lord, will fall apart, my lord. It will automatically get established the late so and so died unmarried, my lord. My lord, the question, my lord, framed by the trial court, my lord. The trial court has no jurisdiction to, my lord, determine this question, my lord, whether the marriage is, my lord, valid or not. The competent authority who decide the, my lord, validation of marriage, my lord, is, my lord, competent authority civil court or, my lord, family court. My lord, this judgment also here, my lord, if, my lord, permit me, my lord. My lord, they, my lord, obtain the, my lord, declaration from the civil court, my lord, if the marriage is valid or not, my lord.
That is only the question, my lord. He is not competent, my lord. Paragraph, my lord. Here in the judgment, my lord, 7, paragraph number 7, my lord. Under section 7(1) explanation B, a suit or a proceeding for a declaration as to the validity of both marriage and matrimonial status of a person is within the exclusive jurisdiction of the family court. Since under section 8, all those jurisdictions covered under section 7 are excluded from the purview of the jurisdiction of civil courts. In case there is a dispute on the matrimonial status of any person, a declaration in that regard has to be sought only before the family court. It makes no differences as to whether it is a affirmative relief or negative relief. What is important is the declaration regarding the matrimonial status. Section 20 also endorses the view which we have taken since the Family Court Act 1984 has an overriding effect on other laws, my lord. My lord, the trial court has no jurisdiction to decide this question, my lord.
How the trial court has decided the issue?
Trial court presume that, my lord, living together, my lord, as a person, and my lord, the deceased person and the, my lord, the, my lord, respondent, my lord, living together in a rented house, my lord, presume that, my lord, they have no valid matrimonial or marriage is valid, my lord, between that person, my lord. This is only the finding, my lord. My lord, finding is, my lord, finding it page number, my lord, 46, my lord. Before, my lord, going to the 46, my lord, kindly, my lord, come to the, my lord, page number, my lord, page number 43, my lord. Decided, my lord, they quoted a judgment, my lord, of the Supreme Court, my lord. 43, my lord.
Yes.
In this regard, I would like to place reliance on a decision of Honorable Supreme Court in case of Tulsa and others versus Durgatia and others, my lord, 2008 for SSC, my lord. Wherein observe that, my lord, at the junction refer may be made to section 114 of Evidence Act. The provision refer to common course, natural event, human conduct and private business. The court may presume the existence of any fact which in things like to have occurred regarding the provision of section 50 and 114 of the Evidence Act together. It is clear that the act of marriage can be presumed from the common course of natural event and conduct of parties as they are borne out by fact of particular cases. Well, only from this judge, they have presumed, my lord, the marriage is valid, my lord. And my lord, my lord, judgment also, my lord, the suit, my lord. This is the, my lord, RSA proceeding, my lord, the Supreme Court decided, my lord. Lord, they're supposed to take, my lord, the declaration from the civil court, my lord. That is the law, my lord. The trial court cannot, my lord. They have no jurisdiction to, my lord, decided, my lord, whether the marriage is valid or not. My only submission is that, my lord, they have, my lord, sought relief from the in proper manner, my lord. From the civil court, my lord, they have obtained declaration, my lord. Only on the basis of assumption and presumption, my lord, the issue is decided, my lord, by the trial court, my lord.
Yes, so who is for the respondent?
Article number 22, I am for respondent lordship, and 23 he is.
What is your response to the submission advanced by him?
My lord, he has stated that marriage cannot declared by trial court, but his ground for appeal is not that lordship. Here, which he has come for appeal lordship, in intestate case lordship, grounds are not for declaration lordship. He has simply said that she is not wife of deceased lordship, but in the and he has read out page 43, Tulsi and others versus Durgatia and others versus lordship and others lordship, where he has read out para 11, but in para 15 lordship, where the partners live together for long spell as husband and wife. Page 43 lordship.
Page
43 lordship.
Yes.
He has read this para 11 lordship. I am reading para 15. Para 15 of judgment. Where the partners got it lordship. Live together for long spell as husband and wife. There would be presumption in favor of wedlock. The presumption was rebuttable, but heavy burden lies on the person who seeks to deprive the relationship of legal origin to prove that no marriage took place. Law leans in favor of legitimacy and throws upon bastardy. Lordship here, lordship, prosecution has proved lordship in succession case number
104.
90 of 13 lordship. All the witnesses have stated that they had married as per Hindu rich lordship, and all witnesses cross-examined. All stated same thing lordship. They are husband and wife, and two sons are sons were his son lordship. Therefore, lordship, honorable trial court rightly decided in favor of the respondent's lordship. And lordship, they have filed second succession by the lordship, appellant lordship, but they have not stated that they know the earlier case lordship. They simply stated that no case has been filed earlier lordship. Whereas they have received a notice from the Miss Z case number 90 of 30 lordship. That fact has not stated by them lordship. Instead of filing WS in that case, they have filed separate succession case lordship. Since there is minor son also lordship, honorable court is right.
Wait, but the question is whether the trial court can decide the issue, patrimonial issues.
But
the status of the parties.
Yes, lordship, that I am saying in ground nowhere he has whispered that.
My lord, page number 7 of my lord, appeal of memo of appeal, my lord.
Page number 7.
7, my lord. Last point, my lord. The number 10, my lord, Roman, my lord. For the learned trial court below erred in law in declaring the respondent one as the wife of the deceased in proceeding under section 372 of the Indian Succession Act 1925, which is only a summary proceeding. We have taken the ground, my lord. In summary proceeding, he cannot decide it, my lord. And my lord, the Supreme Court said, my lord, in various judgments, my lord, the civil court and the family court has the jurisdiction to decide it, my lord, in matrimonial cases, my lord, whether the marriage is valid or not, my lord. And our defense, my lord, in page number 38, my lord, he already married with another 38. Kindly see the 38, my lord. Next paragraph, my lord. Page 38, my lord. Sub paragraph, my lord. We started from the fourth line, my lord. In Miss case succession case number 90/2013, Srimati Ranu Sengswa, Srimati Onu Singh, Sri Dhan Sengswa and Sri Jan Sengswa as opposite party filed their written objection denying the claim of the petitioners and pleading their own case as set forth in Miss case number so. Besides, they also alleged that the petitioner number 1, Srimati the respondent, Mona Lisa Sengswa and her 2 minor sons are not the legal heir of the disease and their name were also not recorded in service book of the deceased with NF Railway Dibrugarh. They also claim that they have learned on inquiry that the petitioner number 1, Srimati Mona Lisa Sengswa is the married wife of one Sri Kusum Das, and out of their wedlock, 2 male children were born. Their father claimed that at the time of his death, the deceased Kalyan Sengswa was resided at his parental house at Kodamuni Vishnu Nagar, Dibrugarh, my lord. My lord, our claim is, my lord, specific, my lord. And my lord, the deceased person resided, my lord, with the petitioner, my lord. And the, my lord, respondent, my lord, resided in rented house, my lord. And my lord, no, my lord, any ceremony or my lord, marriage, my lord, solemnized between the, my lord, deceased person and the, my lord, respondent, my lord. And my lord, the disputed question arises, my lord. Therefore, my lord, civil code or my lord, the family code interfere, my lord. Because, my lord, this is the, my lord, matter of fact, my lord, which, my lord, decided to, my lord, lay both the party, my lord, proper, my lord, evidence, my lord, before the trial court, my lord. Sorry, my lord, family court or my lord, civil court, my lord. My only submission is that, my lord, the trial court has no jurisdiction to decide this question, my lord. My lord, may set aside the, my lord, the impugned judgment, my lord, and my lord, directed to approach before the civil court, my lord, and obtain, my lord, declaration from the civil court or family court, my lord. Only I have much my prayer on it.
Yes, Mr. Boro, anything to something?
My lord, as these are connected cases, my lord, I would like to adopt the submissions made by my learned senior friend. But apart from that, your honor, what is happening here is these are 2 cross suits, my lord. 2 cross suits are there. One has been filed by the wife and the sons for the succession, that is Miss Case Succession 90/2013, and the others were filed by the siblings of the deceased. That is Miss Case Succession 104/13. So these are 2 cross suits. As per the submissions made by my learned friend, that the marriage is not valid. As such, the jurisdiction court does not have the jurisdiction whether to decide whether the marriage is valid or not valid. In my humble submission, my lord, if that is the scenario, my lord, all the succession cases which are filed will, the succession courts will be debarred from exercising their jurisdiction in all the cases, my lord, because in succession cases, what has to be ascertained is that whether the petitioners in a succession cases are the legal heirs or not. Here, it is not a question whether the marriage is valid or not valid, whether the marriage is void. If that would have been the question, then the family court or the civil court would have come into play here. In this judgment, my lord, this is a very well-reasoned judgment. Extensively, this is not a summary proceeding because extensively witnesses came into the dock. They were cross-examined, and after that only this arrived at. Whether the marriage is valid or not, that is not the question here. Here it is the question whether the petitioners in a succession case are the legal heirs of the deceased or not. And that has been amply proved. The wife, it was their stand that I was married to another person, like Kusum Das. But if your lordship goes to the judgment, it has been, with their evidence, they have not been able to establish the fact that I am married to another person, namely Kusum Das. And they are heavily relying upon one Exhibit 5, which is a letter issued by the railways stating that I am not the wife, but that stand has been demolished in the cross-examination. I'll show, my lord. In page number 54, my lord. Miss case number 104/13, which had been filed by the siblings of the deceased. In that case, my lord, official witness was called by from the railways who had issued the letter, my lord. If before that, my lord may produce page number 28. This is the letter, my lord.
Page number 28.
28, my lord.
Yes.
My lord, page number 28 of the item number 23, my lord, appeal. Because I am appearing in that case, my lord.
Page number
23, 28, my lord.
Yes.
My lord, this is a letter issued by the Assistant Personnel Officer for Chief Workshop Manager, NF Railway Mechanical Workshop, Dibrugarh. It is addressed to me as well as Srimati Ranu Senchua, who is the appellant. Subject is succession certificate. It is inform you that on going through records, it is seen that late Kalyan Senchua, who was an employee of so-and-so, expired on so-and-so while in service. He was a bachelor. He did not execute nominee. However, from relevant document, it is seen that he left behind the following blood-related members at the time of his death. Then 1, 2, 3, 4, the appellant's name have been shown. Then since both of you have claimed the final settlement amount of late Kailan Senchua, you are hereby asked to obtain the succession certificate from the competent court of laws and submit the same to this office immediately. The final settlement amount in respect of so-and-so is funds are given. Now, basis on to prove this letter, the person who had issued this letter was called for cross-examination. That is in page 54.
Yes.
Page 54, my lord, first paragraph, second line, my lord. It may also be stated here. My lord has got it.
Yes.
It is also, it may also be stated here that in Miss Succession 104/13, in his cross-examination, the official witness, Sri Netai Chandra De, PW10, has clearly admitted thus. In the letter, the department reflected about the names of the kins after having personal inquiry. It is correct that at that time, I also found Mona Lisa as wife of the deceased, but we did not mention her name in the letter. Moreover, it is important to bear in mind that Exhibit 5, Exhibit C letter was addressed also to Srimati Mona Lisa Senchua, who claimed to be the wife of late Kalyan Senchua. Mere fact that as per his service records, late Kalyan Senchua died as a bachelor cannot be a conclusive proof of the fact that he was not married to Srimati Mona Lisa Senchua. That is the point, my lord. So simply because of not mentioning, that does not imply that I am not the wife of the deceased. And my lord, in Miss case number 90/2013, all the witnesses have stated, my lord, the neighbors, 5 neighbors were there, and persons who were acquainted with me from before They have also come and deposed, my lord. And their cross-examinations, in their cross-examination, their evidence could not be demolished. Even the the landowner in whose house I resided with my husband, he has also come. So this is a very well-reasoned judgment. This could not, may not be interfered with, my lord, because I have been rightly issued the succession certificate. An order has been passed, whereby I have been directed to be issued the succession certificate. As such, my lord, just because the issue is not that whether the marriage is valid or void or voidable, that is not the question. If that would have been the question, it is very much, I would have also admitted, my lord, that family court or the civil court would have the jurisdiction. But here, the question is whether I am the wife. And that has been amply proved, madam, with all the evidence. 10 number of prosecution, plaintiff witnesses have come. And they have stated, and their cross-examination stands because they could not be demolished. Nothing could be demolished.
Well, there is no witness to actual performance of the marriage, my lord. Or any, my lord, ceremony, religious ceremony, my lord. Only stated, my lord, PW1, my lord, and my lord, the brothers of the, my lord, the respondent, my lord. Hostile, my lord. Independent witness, my lord, never said, my lord, the marriage was solemnized, my lord, and I am the witness, my lord. And my lord, the documents, my lord, which my lord, my learned friend, my lord, pointed out before this honorable court, my lord, this is also disputed, my lord. This all disputed question, my lord, resolved by the civil court, my lord. And my lord, the issue, my lord, framed by the trial court, my lord. Page number, my lord, kindly, my lord. The only question decided, my lord, whether, my lord, he is the legal wife or not, my lord. Meaning thereby, my lord, they decided, my lord, validity of marriage, my lord, between the respondent and deceased person, my lord. And my lord, my submission is that, my lord, the trial court has no jurisdiction to decide that question, my lord. And my lord, I'm only, my lord, my prayer only is that, my lord, if the respondent is a legal wife of the, my lord, deceased person, my lord, obtain, my lord, declaration from the, my lord, civil court, my lord. Nothing much, my lord. My only submission is that.
Okay.
My lord, if my lord peruses the evidences starts from page 43, my lord. Item number 23. Page 43, this is a very descriptive judgment, my lord, very rational, with all the reasons, my lord. The evidence was scrutinized, my lord. And if at all there was a, my lord, eventuality that I am not the wife, they could have approached, my lord, the civil court at an earlier point of time. Now at the stage of appeal, again being remanded back and then again being the parties being referred to the civil court, this will be a wastage of time, my lord. And this is a succession case, my lord. If at all the succession, they have not challenged my lord, if succession case, the succession certificate is fraudulent or something like that, my lord, they could have very well approached the civil court for a decree nullifying the succession certificate. Now really getting the parties again to the civil court to get the status that I am the wife, that is not within the jurisdiction of a succession case.
Relief get in proper manner, my lord. Not abusing of process of law, my lord.
a witness on this particular year, Lordship. It was not, no evidence was given to the defendant. So it's it's based on an income which is not proved before the trial. In fact, it may have been taken as the highest category of a minimum wage kind of that kind of, not even it's not giving due regard to the homemaker's role and not just that national income. That national income, if that is not proved, then this could have been resorted to, Lordship.
No, is there any
the
evidence
high
of
skill
the
level-
taking 1/3 of income of the husband as her
Yes,
income?
that husband's income was not proved, Lordship.
Not proved.
Yes, Lordship. That's the judgment says, Lordship. But he considered it reliable. That is it's based on a belief which we ought to have been given an opportunity to examine that. That's my short submission. My ground is this.
So which paragraph you read?
This is page 8 of the judgment. Page 8 of the judgment, Lordship. Para number 9. Lord. Also, the claimant had tried
So
to
no
prove
document was executed in support of the
yes, Lordship.
claim of his receiving salary of ₹51,000.
Yes, Lordship. Lordship may come to page number 6. Their evidence, what they wanted, tried to prove as the income, Lordship. It is after that was done. This
Page
was
number 6.
Page number 6, last part, Lordship.
Yes.
The claimants have asserted, Lordship, last just five lines before the last line. The claimants have asserted that the deceased worked as a tailor in Sombut Ladies Tailoring at Barpeta Road, wherefrom she used to earn an amount of ₹15,000 PM. They also stated that deceased also earned an amount of ₹5,000 from the animal husbandry at the time of her death. To prove such contention, claimants have failed to produce any kind of evidence, either documentary or otherwise. In fact, CW1 during his cross-examination stated that his deceased wife was a housewife. This is as such shall be considered as non-earning member of the family. That is not that's a judge tribunal's observation. Since the deceased was a housewife oblique mother, the claimant number 1, 2, 3, husband, son, and daughter got equally affected by her death. As such, the claimant numbers 1, 2, 3 would be considered to be dependents on in the present case. So this since there is no evidence, Lordship, that was relied on. So from this, even if that she was claimed alleged to be doing something, from that point of view, even if she is considered as a Lordship, skilled worker, which takes into being in the homemaker's role also. Not just that's the highest category for non-earning persons. That's my only submission, Lordship. And as regards the other part, Lordship, I have some submissions later on after he finishes his, Lordship. His appeal is on a different ground, on the question of permit loss. Challenging that direction for pay and recovery.
No, I have no challenge.
Am I gonna?
No.
Sorry, it's this, I got confused. It's his appeal. No,
My lord, to this point, Lordship. My lord, first of all, my lord, she was, my lord, considered as my lord non-earning member, Lordship. Why? Now, so far as my lord, the income of my the husband, Lordship. Of course, my lord, no document was exhibited. And income tax, my lord, return was also not exhibited. But this is, my lord, statements under section 165 of Evidence Act, Lordship. My lord, question whether section 165 Evidence Act can be my lord, applied in the MSCT proceeding, Lordship. 169 of the Motor Vehicle Act, kindly see, Lordship. And the Act 169.
68. Procedure and powers.
Lordship. 169 procedure, Lordship. Got it. May I read, Lordship? Procedure and powers of claims tribunals. In holding any inquiry under section 168, the claims tribunals may, subject to any rules that may be made in this behalf, follow such summary procedure as it thinks fit. The claim tribunals shall have all powers of civil court for the purpose of taking evidence on oath and of enforcing the attendance of witnesses and of compelling the discovery and production of documents and material objects, and for such other purposes as may be prescribed. Now, my lord, 165 Evidence Act, Lordship.
Hmm.
165 Evidence Act, Lordship. Judges power, Lordship. One 165 judges power to put questions or order production. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witnesses or of the parties about any fact relevant or irrelevant, and may order the production of any document or thing, and neither the parties nor their agents shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witness upon any answer given in reply to any such question. Now, here in this case, Lordship, my lord, it is under section 165, the judge has ample power, Lordship, to put any question, Lordship. My lord, award, my lord, just compensation, Lordship, the tribunal has, my lord, exercised 165 power. And during exercise of that power, Lordship, it is found that the husband of the deceased was a, my lord, government employee. He paid income tax return 13,000 per annum, Lordship. So from that amount, Lordship, it was considered, Lordship, the income, 1/3 income of the husband, my lord, as a income of the, my lord, deceased Lordship wife. So in my humble submission, this is, my lord, correct judgment, Lordship.
There is no doubt regarding the power of the court under section 165 of the Evidence Act.
Yes, Lordship.
But the question is, are you not supposed to produce the minimum documents to show that your earning is rupees 51,000?
While during deposition, it
Then,
was.
what
was-
document you have produced before the tribunal to show that you were the employee of that department? And it
In
was
that case,
discovered?
then in that case, it must be remanded back, Lordship. Well, it is on my record, it is on record, my lord, after putting question to the, my lord, witness, Lordship, it was revealed, it cannot be denied. Now, it may be remanded, my lord, I will prove, Lordship. And the respondent will get opportunity to cross-examination, make cross-examination, Lordship.
Then, Mr. Goswami, is it the only decision of the Supreme Court to determine the income of a homemaker?
No, sir, there are other decisions also.
The same procedure is followed?
No, sir, there's not the same procedure. I'll just. There's another decision based on the, of course, she was a working woman so that was in that case, her own income was considered another decision, but not. Yeah. That's why it's not if I could say. There is another decision. There's another decision the same year, Lordship. That is which one was first? 26, 411, and yes, one decision after that. This was delivered in Arunachal to Kutek, obviously.
Let us do one thing.
Arun Kumar is about this.
We'll list it.
10.
matter
This was
again.
in 10. There's a decision of 11, Lordship.
Same procedure is followed?
No, Lordship, it's a slightly different. I have this judgment. This is after that Arunachal decision. It doesn't seem to be in that line. Lordship. Some notional income was taken. This is the edited official of a copy of that. There are some other decisions also. Lordship, I'll come back to it. This is one decision I found, but this is definitely after that decision. There is another decision. This is of a working woman, so that does not apply. That her own income was considered. She was a working woman. Also after that decision. I do not. Working woman was in that. Huh? Sunil Sharma visited, but she was a working woman.
This will not be applied in this case, Lordship.
Working woman is applying.
Some more decisions are there, perhaps.
Yes, Lordship. And I have another one, Sunil Sharma visitor Singh. But this will not apply because the deceased was a working woman.
Yeah.
So that's after a, there will be definitely other issues, Lordship.
Let us fix another date. We'll hear again. And instead of remanding the matter, we will try to dispose of the matter here.
Yes, sir.
And the claimant is also my suffering from my lord kidney problem, lordship.
Yes, court will fix a sorted. Part Mr. Ardusami, learned counsel for the appellant, and Mr. Ahmed, learned counsel for the respondent number.
My lord,
all the
1, 2, 3 and 4.
Respondent number 3 and 4, and Mr.
1, 2, 3 and 4.
I am for the item number 40. And
Respondent number
14.
14.
no, on item number 14, I am the appellate. And in item number
13 part, list the matter for further hearing on. Sorted. 7 to 7.
Item fixed at 2 p.m. Item number 33. And item number 2 of production list.
Lord, in a nutshell, the story of the whole case is this, my lord. There is a bus station of the Assam State Transport Corporation, shortly we call ASTC, in Moran town under the Dibrugarh district. The case of the plaintiff was that the land where our station stands, one portion of the land, belongs to his father, and his father had a written agreement with the ASTC on rent. And that written agreement says that we have to pay rent 33 rupees per annum. And according to the 33 rupees per annum. And according to the plaint, my lord, that agreement was executed sometime in 1947-48. And the plaint says that we were paying the rent till September 1950. And from October 1950, we have not paid the rent. So they have approached the court for recovery of rent, area rent, and a permanent injunction refraining ASTC from making any permanent construction of a land. The cause of action arose in 1950, October 1950. We did not pay. Had it been a case of recovery of possession or eviction, then I would not have argued this. But they said that it's a simpliciter money suit, my lord. In one word, it's a simpliciter money suit, which was preferred. In 2005, cause of action were aroused in 1950. Then, my lord, they failed to produce the written agreement depending upon which the claim was made. They also failed to exhibit the title deeds. And considering all aspects, the municip rejected the suit, dismissed the suit. They went on appeal. An appeal on some erroneous ground, reversed the order, judgment. And against the judgment, we preferred an appeal, a civil revision petition, where we were 633 days delayed. And the registry said that the delay is 633 days. And the delay, condemnation of delay IA is, my lord, 1540-2021. Lordship may kindly take that IA 1540-2021. And before going to the petition of condemnation of delay, my lord, I would like to show to your lordship, my lord. Actually, the delay is not 630 days. Delay is 115 days only. Why, my lord? I have given a written note, my lord, and so the judgment of the Honorable Supreme Court. Order of the Honorable Supreme Court. The written note, my lord. The title appeal 11/2013, judgment and order dated 22 March 2018 made impugn herein, passed by the Civil Judge Senior Division, Dibrugarh. The petitioner came to know about the said judgment only in the last part of April 2018, that is supposedly on 30th April 2018. Therefore, the instant CRP or an RSS would have been filed within 90 days from 30 April 2018. That is to say, on or before 29 July 2018. However, the instant petition was filed on 16 August 2021, and according to the registry, there is a delay of 633 days.
Exclusion of limitation by the Honorable Supreme Court due to COVID-19 pandemic. Miscellaneous application application number 21, 2022, order dated 10 January 22, passed by the Supreme Court. I have annexed that order. My lord, the Supreme Court ordered to stop the clock of limitation for the period 15/3/20 to 28 February 22. That is, from 15/3/20 to 31/12/2020, 219 days, 365 days in 2021, and 59 days in 2022. Therefore, Honorable Supreme Court has condoned a total delay of 715 days. And therefore, limitation for the instant case shall not run from 15/3/20 to 16 August 2021. Therefore, from 15/3/20 to 31/12/20, 291 days, 11/21 to 15 August 2021, 227 days. Therefore, total of 518 days have been covered by the Supreme Court order. And 633 minus 518 is equal to 115 days. And this order I have annexed to this, my lord. If your honor lordship can read paragraph 5 of that order. Supreme Court order.
No, there is no dispute about.
Now, my lord, just why the registry has recorded 633 days, because this petition was filed prior to this order was passed by the Honorable Supreme Court. Therefore, registry has calculated it as 633 days. So minus 633 minus 518 is equal to 115 days.
So the calculation was made prior to passing of the.
Yes, Supreme Court order. That is why 633 days registry has showed.
That period has already been excluded while calculating 633 days, my lord.
No, how
yes,
can
yes,
it?
that is there. The original judgment, my lord, in the appeal is of 22/3/2018.
How can it be calculated?
Yes.
See?
20 against, this is the CRP against the order judgment dated 22/3/2018, my lord.
$1540 is the delay continuation petition.
It was 365 plus 360, that is 700 minus 2018 to 19, 365. ठीक है सर 1500 2019 19 to अपने जितने को से 15 थी 2020 जितने डेट ऑफ पूरा है वो से 365 तो 700 की मान बातें है ये डन है this is already excluded
Can I exclude court?
पूरी से
And a petition was filed prior to the order passed by the Supreme Court. This order passed by the Supreme.
Mr. Somo, have you checked this calculation sheet of the registry?
No, my lord, I have not seen.
Please go through it.
and moreover, my lord, in another IA that is connected here today, 3397/2024, they have stated in paragraph 11 that they have withdrawn this, my lord, IA. 1540, which is now taken up by your lordship. This is the statement made in IA civil number 3397, my lord. Not okay. This is the another IA 3397, my lord. This is also filed for condonation of delay, my lord.
No, it's
For
not.
630 days again.
No, no, no.
I don't know, it's a misconceived, my lord.
No, no, my lord. I'm coming, my lord. This
There
six, where the calculation is, my lord, I've gone through. Same thing that I have written. But there will be difference of 30 days. I said the order was passed on, judgment was passed on 22/3/2018. Date of filing CRP is 16 August 2021. They have calculated, my lord, from 23/3/2018, from 23 March 2018 to 31 December 2018, 284 days. 2019, 365 days. 2020 up to 14/3/2020, it is 74 days.
Yes.
So
43, my lord.
1 minute.
Last
Let me act.
Yes.
723 days. 90 days limitation. Minus 90 days is 633 days. So we filed our appeal in 21. So clock of limitation, according to Supreme Court, clock of limitation should stop midnight 14th March 2020. Where is the deduction? Where is the deduction? Deduction is not there.
This period
Oh,
of extension is.
had it been filed,
Sorry.
my friend would have been correct in saying that if I have filed the appeal after 28 February 2022, we filed in between the holiday period. The holiday that was declared by the Honorable Supreme Court was 15 March 2020 to 28 February 2022. That is total 715 days. From this span, I get for my case 518 days. Because according to the Supreme Court, the clock of limitation stops midnight at 14 March 2020 and restarts on 1st March 2022. So till the date of my filing petition on 16 August 2021, the limitation did not start. Kindly appreciate that. Limitation clock was stopped. So calculation of delay should be up to 14 March 2020. From 2008. From the date of even judgment, if Lordship calculates from the date of judgment, then also after 90 days, I'm entitled to a relaxation as per the Supreme Court orders. Is 512 days, 518 days. So 630 days, 33 days minus 518 is 115 days. This was done, my filing is, my lord, 5/11/2024. This calculation was, sorry. But this kindly take up the matter on interlocutory application 1540 2021, my lord.
Yes.
This petition was filed, my lord, to my information. Where the registry has marked as the delay is 633 days. And that petition also right now that your lordship has given to me, in that petition also the delay is shown as 633 days. It seems, my lord, it is a transport brief, my lord. I have been newly engaged. It is seen, my lord, that this petition was filed twice.
Well, here there is a problem, my lord, due to perhaps due to change of the council. That initially Mr. Aramdas was arguing the matter, and he prayed before your lordship that he filed one petition for converting this CRP into regular second appeal.
That is there. That
Yes.
petition there.
Now, there, my lord, in that IA, we take an objection. If CRP is not filed within the prescribed period of limitation for filing appeal, then such petition cannot be converted into appeal. And since there is admittedly delay, therefore, he was submitting that he was supposed to file regular second appeal, and therefore he has withdrawn this petition, madam.
No, there is
This is the statement made in the IA 3397, madam. Para 11. He has withdrawn that. And therefore, lordship, he filed thereafter a subsequent IA praying for continuation of delay of 632 days so that he could file the appeal. Now he has not filed the appeal as of till date, my lord. He can very well do it by filing a regular second appeal along with continuation of delay application, explaining till today. However, for the period time spent in the honorable court, if it is as per him is a wrong forum, under section 14 of the limitation act, he will get that period. Now he has to explain that in the subsequent petition filed by him, there also he has mentioned the delay of 632 days only.
Because that I mentioned this 632 days because of the fact that the order of this Honorable Supreme Court passed later on, giving a retrospective effect.
No, you don't that. Para 11, my lord, of IA 3397, my lord. Para 11, that the petitioner begs to state that they had earlier filed interlocutory application which was numbered as interlocutory application number 1540, this present one, my lord, 2021, dated 16/8/2021. And the petitioner was pursuing the said application till so-and-so. On so-and-so, the petitioner withdrew the IA application to file a fresh interlocutory application in the connected regular second appeal. My lord, there is no connected regular second appeal he has filed, my lord. And therefore, the order whereby in this IA notice was issued, my lord, the honorable court, my lord, observed that there is no IA regular second appeal file. Order dated 11/11/2024, my lord. This last line. And pursuant to the order also, my lord, he was supposed to take steps for deleting the respondent numbers 1 and 2 who already died. He has not done that also. And so far this delay is concerned, 632 days, which he filed subsequently, he has not said that the time spent in this present proceeding for seeking it to be converted to a second appeal. So as of now, the total delay, my lord, if this petition is lordship takes up, total day of delay will be 1818 days.
Oh, my lord.
It is 4 years, almost 4 years, 5 months.
Well, at 518 days, that holiday that I got from the Honorable Supreme Court said minus. Even if I accept my friend's argument, then also 515 days is a.
Mr. Samoa,
My lord.
so whether this petition.
My lord, this IA, my friend has shown it 3398.
Yes.
I'm not aware of that IA. In my file, it is not there. Well, my respectful submission is, my lord.
But Mr. Das, whether any order was passed regarding a withdrawal of this
No,
IA
there is
member?
no order.
Yes, kindly see, that is in a wrong IA. Lordship in IA 3397 2024. Although he made the statement page 16 in this IA, my lord, this order dated 19/9/2024 passed by your lordship in that IA. However, I remember he made a prayer to withdraw the condonation application as is stated in para 11. Lordship will find this order at page 17 of this IA 3397, my lord. 19/9/2024.
Page number?
17, my lord, the operative part.
Yes.
Third, Mrs. So-and-so, counsel for the applicants, Mrs. So-and-so, respondent number so-and-so. Mr. Das, learned counsel for the applicants, submitted that he has the instruction to withdraw this interlocutory application to file a fresh interlocutory application in the connected RSA. But there is no connected RSA, my lord. The prayer is all is allowed. Accordingly, I stands however with liberty with the applicants to approach this court by filing an appropriate application. Now, what I understand from this order, my lord, since his prayer for converting the appeal is already there, and we made the, my lord, our submissions, since there is already delay, so that cannot be converted, he can very well explain the delay by filing a fresh RSA, my lord, with the grounds as per the section.
No, that cannot be, my lord. What I'm saying, I'm saying, let me complete, because I am the mover, you will reply. What
It
is
is already.
what is the
petition.
problem is this, my lord, there is no order of withdrawal, but acceptance order of withdrawal in IA number 154021. If lordship can find any order, then perhaps I will be wrong in saying so. But so far my knowledge goes, there is no order saying that IA 1540 is hereby closed. No, there is no order as such. And if the previous council said before this court, previous council has said before this court, then perhaps it is without the instruction. Number two. Number three, my lord, fact remains, whether the CRP converted to a RSA or not, fact remains that there are delay. The first, your lordship, in my respectful submission, has to deal with the delay. Thereafter, your lordship will see whether the CRP can be converted to a RSA or not. I'm coming with the judgment of the Honorable Supreme Court that these are the procedural flaws on the part of the councils, not on the part of the litigants. Supreme Court says that don't go for all this. If it can be converted, then do it. Therefore, my respectful submission would be, my lord, whether right now my friend has shown this I am not aware of that IA in my file, this 3397 IA is not in my book, in my file. But
Mr. Somoa, let us do one thing. You go through all the file.
Yes.
And you press the proper application before this court.
Correct. Correct.
So, you see here, there is an order of withdrawal of one application.
Yes.
Who is Mr. Das?
I understand. My friend he is not saying like he has shown to me, but I am not aware about that thing.
No, therefore.
But
please
what
go to
my
the
respectful
record.
submission would be is, my lord, 1540 IA is not closed yet. It was prayed, it was stated that we will withdraw, but it was not withdrawn. Neither there is any effective order closing that IA. So for the purpose of delivering substantial justice, my lord, there are some problem on the execution. There is an execution proceeding file. It's pending there. They are going to sell out our properties. This is state properties, my lord. There are sufficient inconvenience will be caused. That is why.
No, that's all right. But you are not sure which IA you are pressing now.
Well, I am pressing 1540 because it is not closed.
No, but
Rather,
there is
rather
an
I
order
would
that-
now, I would now press before lordship that 39 may be closed.
No, there is one statement in the application itself.
And সেখানেই তো আমি
Moreover, my lord, there is.
Okay, Mr. Somo, you tell me when the next date is fixed before the
6th of August, my lord.
6th of August.
My lord.
Yes, we will take it up on Friday.
Yeah.
You please go to the record.
My lord.
And thereafter let this court know which IA has to be dealt with by this court.
My lord.
Huh?
My lord. But one thing, my lord, if I'm not wrong, my lord, if lordship confirms me, that 1540, there is no effective order closing that I.
No, maybe, but there is a statement
The statement is
in the application filed by TSCC.
yes.
All right, I'll take the necessary.
Mr. Das, please show him the statement.
Yes, sir.
And here is, my friend was saying, is right, my lord Justice Surana's order is there, which says that this should not be a CRP because of the fact that the original title suit was just a simpliciter money suit. Therefore, it should be a second appeal. And that is why we file after that order of the Honorable Court, we filed a petition praying before this Honorable Court to convert the CRP to a RSA. That is why it was not, some flaws are there, of course.
And in that order, in fact, my lord, there is a 21/12/2023 order passed in this IA, my lord, 1540. Thereby, the Honorable Court earlier occasion say that you have to show the maintainability of your CRP. So that is also his burden is there.
That is why maintainable CRP is not maintainable because of the fact that the title suit was not directly under the Rent Control Act. Had the title suit been under the Rent Control Act, then the second appeal would not have been maintainable. So my earlier counsel preferred the CRP. But when this Honorable Court, my Lord Justice Surana, after going through the whole things, it was realized, and actually this is an advice from the Honorable Court, and we are obliged to it, that this is a simpliciter money suit. Therefore, we should go for a second appeal, regular second appeal. That is why we preferred an IA, praying before this court that convert this CRP to an IA, to an RSA.
Okay, we'll consider it.
But that is, on this point, I brought a judgment of the Honorable Supreme Court, which says these are all procedural flaws, maybe on the part of the counsel, or maybe the counsel did not advise the client properly.
Also, we have to condone the delay.
That's what I'm. My lord,
We'll see.
whether lordship converts the CRP to a RSA or not, to admit that application, so lordship has to condone the delay. The delay is admittedly 633 days.
No, that we will take care of. But you first ascertain which petition is to be pressed before the court.
My lord,
Uh,
this is a chaos created by previous
chaos,
counsel.
chaos.
No, why? Why not? Truth is a truth.
But Mr. Somo, you keep this written note with you.
My lord.
You place it on next day.
My lord. On Friday.
Third, Friday.
Third,
Mr. Somo learned for the applicant. And
Next Tuesday
supplicant,
morning,
release the matter again on Friday for further consideration.
Tuesday
No, 25th. My lord may fix a timing on this, my lord, on 25th.
It's okay, my lord.
If
It's
it
2 p.m.
2 p.m.
Timing items 20.
May I please, Lordship? This is against the money suit decree. The appellant is the defendant. Appellant is the defendant in the money suit.
Pardon?
Appellant is a defendant
Okay.
in the money suit.
Yeah.
Substantial question of law framed on 22/12/15.
Yes, Mr. Lotko, ready? So the money suit was executed for recovery of 40,000 rupees.
Yes, my lord.
40,000.
With compensation of 5,000, 45,000 with interest of 6% interest. 6% interest also. Deposit. My lord, the substantial question of law Number one was whether the decision of and conclusion reached by the learned court below is perverse to the evidence available on record. Perversity is number one. 22-12-15, your lordship. Order.
So the trial court has decreed the suit,
Yes.
and first appellate court has reversed it,
Upheld.
affirm it.
Upheld. So this is the second.
And where is the substantial question of law?
Page number, my lord, it is 22-12-15, my lord.
Order dated.
Order dated 22-12-15.
Yes.
Whether the decision and conclusion reached by the learned court below is perverse to the evidence available on record. Number two, whether the learned court below committed manifest illegality in discarding the opinion of the handwriting expert obtained under section 47 of the E-Evidence Act 1872 without any valid reason and thereby arrived at a conclusion regarding validity of the signature by the making a visual comparison under section 73 of the Act and any other subsection of law. So, your lordship, may I go to the trial court judgment first, my lord, where the expert's opinion was discussed and rejected, my lord. Page number 1, 4, my lord.
Page number?
1, 4, 14.
14.
Yes. Of my memo of it. May I read, my lord? It's not a very long judgment. Short judgment. May I read, my lord? The plaintiff's case in brief is that the defendant took a loan of 40,000 only on 2621 from him on execution of a hand note with a promise to repay the same on demand, but he failed to keep his promise till date. Plaintiff further asserts that the demand, the said money given in loan to the defendant several times, but to no result, thus finding no other way, plaintiff approves this quote. Defendant's case is that, my lord, defendant contested the case by filing written statement of the suit inter alia on the ground that suit is not maintainable in the present form and also the lack of cause of action. Defendant denied that he had ever borrowed any money from the plaintiff. Defendant rather averred that he borrowed 13,000. He owed 13,000 rupees only towards the price of betel nut purchased by him and have spent 9,000 only towards medical expense. Ailed husband of the plaintiff. He further averred that thereafter the death of the husband of the plaintiff, he requested the plaintiff to take back the remaining 4,000 only and give a receipt thereof, but the plaintiff did not pay any heed to his words and later on filed this false case against him. Now, my lord, considering the pleadings, both the sides, the framed following issues: whether the defendant borrowed a sum of 40,000 only from the plaintiff, executing a hand note on 261, to what relief the plaintiff is entitled. Only two issues were framed. Plaintiff Muhammad Fatima Begum adduced evidence herself and Abdul Matlib Lashkar as PW2. Abdul Matlib Lashkar is her husband's brother and exhibited the original hand note 261 as Exhibit 1. The plaintiff also exhibited deposition of GW1 as Exhibit A. The defendant, Muhammad Manjurul Haq Lashkar, adduced the evidence of DW1 and Tahir Ali as DW2. Now, discussion and decisions thereof. Whether the defendant borrowed a sum of 40,000 only from the plaintiff. PW1, the plaintiff herself reports that the defendant took a loan of 40,000 only with a promise to return the same on demand but failed to keep the promise. Exhibit 1, the hand note dated 261, executed in her favor. PW1 further deposed that the defendant failed to repay the loan despite repeated requests from the plaintiff. PW1 supported her evidence on oath with the original hand note, Exhibit 1. Exhibit 1 clearly reveals that the defendant accepted the loan 40,000, but Exhibit 1 from the plaintiff to be repaid on demand. Evidence of PW1 was further supported and corroborated by PW2, Abdul Matlib Lashkar, who also deposed that the defendant took 40,000 only from the plaintiff. In cross-examination, defendant failed to extract anything adverse except putting some suggestions that stands nowhere in law without any proof in this regard. Defendant deposing DW1 stated that neither did he execute the hand note, nor did he borrow any money from the plaintiff. He deposed that he had some transaction with the husband of the plaintiff. DW2 also deposed in similar line, supporting and corroborating the DW1. In cross-examination, the DW2 stated that he does not know the signature of the defendant. He also stated that the defendant had very close relation with the husband of the plaintiff. He further stated that he cannot say any transaction had taken between the plaintiff and the defendant after the death of the husband. The DW2 contradicts his own evidence and also takes his credibility by showing ignorance about any transaction between the parties. Hence, DW2 is not reliable at all. In respect of credibility of DW1, he only stated that he did not borrow any money but admitted his debt to the husband of the plaintiff. In respect of execution of Exhibit 1, the same was sent to handwriting expert for examination. The report reveals that the admitted writing and the question writing are not written by the same person. On this point, the defendant DW1 was further cross-examined, where the plaintiff suggested him that the admitted writing was intentionally written in a different way. Though the suggestion was denied by DW1, but the plaintiff, in support of the suggestion, exhibited the evidence on affidavit of the DW1, wherein in Exhibit A1, admittedly the signature of the defendant matches the writing of
Whether the report of the FSL is handwriting expert is available here.
Yes, madam, in the record it is available, madam. In the file D, my lord. File D. Page number 58 or 59, my lord, I have count.
It's number 88.
58 and 59. I think, my lord. That was.
Page number
58, 59. In the
file number
file D, D, my lord.
D.
D.
Page number 59.
58, 59. D.
No. File number D relates to this Hazirias.
May I help?
It's 59.
Yes. Okay, then.
No, whether it was exhibited before the
It was directly sent to the court, my lord. It was directly sent to the honorable court. Honorable court by the forensic department.
It was not exhibited.
It is nowhere mentioned that it was an exhibit, my lordship got it. The opinion is in details, my lord. It is in detail. It is written, my lord, in the opinion how it is different, not of the same person, my lord. The question document and the
But
admitted
the
document.
question is that this was not exhibited. Whether a court will take into account. When the trial court has received it before pronouncement of the judgment or after?
Yes, it is mentioned in the judgment that
Mention.
he mentioned, my lord. May I read, my lord, the later part, my lord, of the judgment?
You have applied for sending the admitted signature to the
by
handwriting expert.
my lord, plaintiff.
Plaintiff.
On the plaintiff's.
By the plaintiff.
Yes, my lord.
He has denied, my lord. He has
I have
denied the
disputed.
signature, my lord, that he has not put any signature in the money receipt, my lord. And he filed an application to send before the FSL, my lord. And FSL opined, my lord. But the FSL report was produced before the court, but it was not exhibited and the officer was not examined before the court, my lord. And apart from this, my lord, the learned trial court, my lord, has compared the signature put in the evidence on affidavit as well as the signature of, my lord, the money receipt, my lord, which the court found that is similar. But when he put his signature in that document which was produced before, which was sent to the FSL, he has put his signature in different manner. And detailed court has observed in the order, my lord.
It is the second substantive question of law, my lord, that whether the honorable court was right in discarding the expert opinion by applying section 73 of the Evidence Act, my lord. And there is a decisions that this is not correct, my lord. The court cannot discard the expert's opinion by merely comparing the signature available in the record, my lord. I mean, it is very much there that in the record, my lord, the signature in the hand note in vernacular, my lord, and in the deposition affidavit in evidence, it is in English, my lord. So how the court came to compare, my lord, and the decision is there, my lord, that it cannot be, my lord. An expert opinion cannot be discarded by comparing, my lord, the under section 73.
Yes, what is the decision?
Yes, my lord. May I read one judgment of Kerala High Court, my lord. Thomas George versus B.B. George Kutti. My lord, paragraph number 13, my lord. Kerala High Court decision. May I read, my lord, paragraph number 13? But the suit is based on the original transaction. Exhibit A5 document is relied on for collateral purpose and not to recover any amount under that document. An expert opinion was obtained with respect to the signature seen affixed in Exhibit A5. Exhibit A5 is seen affixed by two seals belong to the defendant. Both the courts below rejected the expert opinion on a comparison under section 73 of the Evidence Act, which is impermissible. When there is an expert opinion obtained under section 45 of the Evidence Act, it cannot be eschewed on the basis of a comparison of signature under section 73 of the Act. Section 73 of the Evidence Act is a rule of caution and prudence having no overriding effect over section 45 of the said Act. The court should always be cautious to have a comparison of disputed signature with that of admitted one, as the same would particularly be a job of an expert and not of the court. It cannot be at any rate used for rejecting a report of an expert on the field, though the court can reject the same on some other reasons. The rejection of expert report on a comparison under section 73 of the Evidence Act hence cannot be sustained. But the expert report submitted is really lacking in compliance of a requirement as mandated. The expert opinion submitted should be capable of scrutiny by the court and the parties so as to enable them to test its correctness by cross-examination, for which every details of conclusion of the material should be annexed and forwarded with the expert opinion. The identifying characters of the disputed and admitted signature were not recognized with the aid of enlarged photograph of the signature and no such photograph forwarded. A fresh expert report hence cannot be avoided, and for that purpose, the decree and judgment of both the courts below are hereby set aside and the matter be remanded back to the trial court for fresh disposal. The parties shall appear before the trial court on 18/12/19.
Yes. Next one.
Next, my lord, is the 1999 Guwahati 101, my lord. Sham Sundar,
Paragraph number.
paragraph 16, my lord, 16. First, let us may read, my lord. Paragraph 16, 16, my lord.
Yes.
First, let us take up the legality of the finding arrived at by the court regarding genuineness of the signature of the plaintiffs in Exhibit KA. In order to decide it again, we must go back to Section 73 of the Evidence Act. Although Section 73 empowers the court to compare the disputed writing with the specimen admitted writing shown to be genuine, prudence demands that the court should be extremely slow in venturing an opinion on the basis of comparison, more so when the quality of evidence in respect of specimen admitted writing is not of high standard. Of course, that case before the apex court was a criminal case, as pointed out by privy counsel. A comparison of a handwriting by the court with the other document not challenged as fabricated upon its own initiative and without guiding of an expert, and even it is all-time hazardous and recognizable inconclusive. It is unsafe to arrive at a decision in a case where there is a conflict of testimony between the parties as to the general character of a signature. On the correct determination of the genuineness of the signature by mere comparison with the admitted signature, especially without the aid in evidence of microscopic enlargement of any expert evidence. Further, a signature made for the occasion post litem portem merely for the use at the trial ought not to be taken as a standard, as it is likely to be simulated. It may, however, be compared with any genuine writing for all that is owed. The criteria of comparison of signature cannot be a safe guide and surely cannot be the sole guide. But that is what has been done by the learned judge in this particular case. Learned judge did not discuss any other evidence on this point, and based solely on his own comparison, he came to the finding that the signature exhibit are not the signature of the plaintiff. This matter can be looked into from another angle. The document exhibit was filed by the defendant. So, my lord, in this case also, my lord, there is no attesting witness in the hand note, my lord. No witness testified that the petitioner put his signature, my lord. No attesting witness is there, my lord. Only on the basis of the submission of the plaintiff, my lord, and PW1, and my lord, PW2 is not a attesting witness, though he submitted that the money was taken by the defendant, my lord. And only on the comparison, my lord, under section 73, both the judgment said that it is not safe, my lord, that only on the comparison by the learned trial court, the came to the decision, finding that it is the signature of the plaintiff, defendant, my.
Yes.
My lord, may I read now paragraph 4 of the dishonorable court's judgment, Sabharam Das. In Sabharam Das, my lord, the contention of Mr. Bhowmik, learned counsel for the petitioner, in my opinion, is not enabled. A reading of section 67 of the Evidence Act would clearly show that where execution of a document in question is denied, the party relying on that document must prove its execution.
Which paragraph you have relied on?
For my lord, in Sabharam.
For.
Sabharam.
Yes.
Paragraph 4. From second line, may I read, my lord? Second sentence, a reading of section 67 of the Evidence Act would clearly show that where execution of document in question is denied, the party relying on that document must prove its execution and signature of the person who have allegedly signed it. It is admitted position that no evidence has been furnished to prove the execution of the document. In my case, my lord, no evidence is there that the defendant put his signature. Or for proving the signature of the plaintiff on the said document. In these circumstances, it is not possible to accept the argument of Bhowmik that the statement of the defendant himself, BW1, should be held to be sufficient proof of execution of the document and signature. Thereupon, by the plaintiff, requirement of section 67 must be satisfied in that letter and spirit by tendering evidence for proving the execution of the document and signature of those who have signed it. So the signature must be proved, my lord. The courts below, to my mind, were justified in declaring the suit and rejecting the version of the defendant appellant that he had purchased the suit land by registered sale deed number so and so. I find no force in the appeal, which is accordingly dismissed.
Next.
My lord, next, my lord, this is Telangana and Andhra Pradesh High Court, my lord. Bhavanam Chibareddy. Here, my lord, may I read paragraph number 18, my.
Yes.
In Nila Lohita Dasan Nadar, but so and so, the apex court held that under the Evidence Act, two direct methods of proving the handwriting of a person are by an admission of a person who wrote it, by the evidence of some witness who saw it being written by that person. So both these are missing in this case, my lord. Apart from this, there are some other methods of proving the handwriting by opinion. They are by evidence of a handwriting expert, by the evidence of a witness acquainted with the handwriting of the person who is said to have written the disputed writing, section 47. An opinion formed by the court itself on comparison made by the disputed writings with the admitted or specimen writing. So here, my lord, specimen writing was not there. The learned court did not compare with the specimen writing. The learned court, my lord, compared with the signature of the mentioned in the evidence in chief. No doubt from the above, for the handwriting expert's opinion, there is no rule of requirement of corroboration, nor any rule of same can be acted solely as basis but to decide with reference to it for its circumstances and other evidence. Opinion of handwriting expert mainly to be supported by reasons contemplated under section 51 of the Evidence Act. It is needless to say, once there is other reliable evidence of the attester or other direct witness to the transaction covered by the document, handwriting or signature, if in dispute, to prove if it is credible, handwriting expert's opinion running contra to it cannot be a basis to deliberate to disbelieve other cogent evidence. In this case, no other evidence is there, man. Thus, each case depends upon own facts and from nature of evidence available on record for appreciation by the court of prudence and common sense with the experience of man and matter. So, my lord, the learned trial court discarded the opinion of the expert opinion, my lord, in the absence of any other supporting evidence. There is no attesting witness, my lord. For under section 47, no witness that who is familiar with the handwriting of the defendant was adduced, my lord.
So, Mr. Ahmed, you see, the trial court has compared the signature of Exhibit 1 with the Exhibit A1 and found the same or similar.
Yes, Exhibit A1.
Exhibit A1 is the evidence on affidavit
Yes, my lord.
filed by you.
Yes, my lord. That is, my lord, page number 26.
Hmm.
I have annexed, my lord. Page number 26 is the, I think it is type way, my lord. The vernacular is 28. 28, I have the vernacular, which was submitted.
Hmm.
Signature in the topmost of the page, my lord, in particular signed Manjurul Haq.
Hmm.
Page 28.
Hmm. This is the evidence on affidavit.
Yes, my lord.
But page 31 will clear. Last page of memo. This is the exhibit A1 and
31, my lord.
Hmm.
31 also one, it is vernacular and one in English, my lord.
this is
So
exhibit
this
A1.
vernacular is, my lord, compared, my lord. Vernacular signature is compared, my lord. So in the absence of, my lord, other corroborating evidence, as per, my lord, the decisions I have read, my lord, the honorable courts held that it is not safe, my lord, only on comparison under section 73 and discarding the expert opinion, my lord. The opinion is in details, it is mentioned, my lord. The learned
Maybe
trial court discarded
that opinion is also a opinion. And only on the basis of that opinion, the case cannot be discarded or cannot be accepted or declared.
Yes, otherwise, my lord, it is only on the basis of the section 73 it is decided, my lord.
Yes, that part there is evidence of the PW1.
And PW2 also is there.
PW2 is not an attesting witness, my lord. There is no witness, attesting witness in the hand note, my lord. PW2, my lord, I have in my additional affidavit, I have submitted the PW2 one.
Additional affidavit.
Yes, well, I have submitted the PW1 and PW2. evidence, my lord. By an additional affidavit, I have submitted, my lord. Page number 8 of my additional affidavit, my lord, the PW2. High Court.
Yes.
So, my lord, PW2 is the admittedly brother of the husband of the PW1, my lord. My lord, may I read the vernacular or the I had submitted a translated copy?
The
My,
translated one.
may I read the translated copy? Page number 11, my lord. I, Muhammad Abdul Matlib Laskar, son of Sunahar Ali Laskar, so and so. The plaintiff of this suit is my neighbor of the same village. I know the plaintiff, the defendant, by executing hand note in favor of the plaintiff borrowed money. The defendant put his signature in the suit hand note in my presence. Exhibit 1 is the hand note executed by the defendant. Exhibit 1.1 and 1.2 are his signatures. Defendant has borrowed rupees 40,000 against the hand note. The plaintiff had demanded for refund of the said amount on several occasions, but due to non-payment of plaintiff's money by the defendant, the plaintiff has filed this suit against the defendant. It is mentioned here that the plaintiff is the wife of my younger brother. The averments made in this affidavit are written as per my statements, and after reading and knowing the same is true and correct. Cross-examination. On oath, there was no mention of place of execution of Exhibit 1. It is not a fact that the defendant did not receive any amount from the plaintiff or did not execute Exhibit 1. So this is the evidence of PW2. Though he, my lord, stated that he was the defendant.
Going through the evidence of PW2, can it be said that you have been able to rebut the evidence?
Yes, my lord.
How?
Yes, he stated, my lord.
The witness only admitted that there is no mention of the place in Exhibit 1.
Yes, my lord.
Whether on that count alone the evidence of the PW2 can be discarded?
No, my lord. But my lord, though he mentioned, my lord, but his signature is not there, my lord, as a witness, my lord, in the hand note, my lord. Hand note is the Exhibit 1, my lord. Exhibit 1.
No, his signature is not there.
Yes, my lord.
But he has exhibited your signature there. There's Exhibit 1.1 and 1.2.
Yes, my lord, he exhibited, my lord. But my lord, the Exhibit 1, there is no witness, my lord. He is not attesting witness, my lord. Though he, my lord,
May not be, may not be.
though he, my lord, deposed that he was present. But my lord, in the hand note, my lord, there is no signature of the witness. My lord.
Maybe.
My humble submission, my lord, the decisions I have placed, my lord, on the decision, my lord, it reflects that the only on basing on section 73, in the absence of other evidences.
No. There oral evidence are there?
Oral evidence.
PW1 and PW2?
Yes, my lord, oral evidence.
Page
is
16
there.
of the trial court judgment, my lord. It will clear. From my lord, one.
Sit down, please. Let
sorry.
him complete.
Sorry.
Yes.
So my lord, oral evidence is there, my lord. But the documentary evidence, my lord, where the documentary evidence is there, the hand note itself, my lord, and there is no attesting witness in the hand note and the learned trial court, my lord, there was no evidence adduced as per section 47 also, my lord, that the examining someone who knows the handwriting of the petitioner, that was not there, my lord, and no attesting witness is there. No witness is there, my lord, except this oral witness, my lord, oral evidence. And it is a my lord, case of documentary evidence, my lord. The hand note, the whole case is based on this hand note, my lord, a documentary evidence, my lord. And the
But the
documentary
evidence on affidavit and the hand note, both are all documentary evidence.
Yes, my lord. So since the case is based on documentary evidence, my lord, only based on the oral evidence of PW2, my lord, whether it will be safe, my lord, to decide the case by comparing the signature, my lord, in the light of the decisions I have placed here before your lordships. It was not a safe, my lord, to discard the expert opinion, my lord. Only on the basis of oral evidence, my lord, that my lord cannot come to the conclusion that my lord
Okay,
he has.
do you have any other point?
I had adduced, my lord, the DW2, my lord, in my additional evidence, additional affidavit, my lord. DW2. Page number 12 of my affidavit, my lord. It is not so much important, my lord, the DW2, though he deposed that, my lord, regarding the transactions, page number 13, my lord. He is a, my lord, school teacher, colleague of the defendant, my lord. And page number 13, my lord. He has supported the case of the defendant one, my lord. Nothing more than that, my lord. So my submission is that, my lord, in a nutshell, my lord, based on the thing, there is a supplication of law, my lord, number one, that regarding the, my lord, the admission of the defendant, that he has, there is a suggestion, my lord, that the defendant has put his signature in the sample question intentionally in a different way, my lord. That was a suggestion, my lord. But the learned court below in appellate court, my lord, held that it was an admission, my lord. But it was not an admission, my lord. It is mentioned in my PW1, page number 26, my lord. Page number 26.
What is the evidence of the DW1?
Yes, well, page number 26, my lord, of
20?
my memo of appeal, 26. DW1. DW1. May I read from second paragraph, my lord?
Not necessary.
Not necessary. My lord, may I read the cross section only on page number 27? Second last part, my lord. There was a suggestion. It is not a fact that as I have deliberately put my signature differently in Exhibit B, expert could not ascertain it. It was a suggestion, my lord, but it is held an admission in the judgment of the appellate court, my lord.
So in the evidence in safe, you have put your signature as B1, B2, and B3 in Exhibit B. And the learned trial court has compared the same under section 173 of the Evidence Act, and therefore arrived at the finding.
B1, B2, B3 are the signature of the, my lord, evidence, my lord. Evidence in chief and cross.
Yes, what is your submission?
My lord, regarding the evidence, my lord, page 16 of the trial court judgment, my lord. In cross-examination, the defendant failed to extract anything adverse against, except putting some suggestion which tends nowhere in law without any proof in that regard. The defendant deposing as DW1 stated that neither did he execute the hand note nor did he borrow any money from the plaintiff. Rather, he deposed that he had some transactions. This is, my lord, vital. DW2 also deposed in the similar line supporting the and corroborating DW1. In cross-examination, DW2 stated that he does not know the signature of the defendant. He also stated that defendant had very good relation with the husband of the plaintiff. He further stated that he cannot say if any transaction had taken between the plaintiff and the defendant after death of her husband. Thus, DW2 contradicts his own evidence and also shakes his credibility by showing ignorance about the transaction between the parties. Hence, DW2 is not relevant. Now, my lord, PW2, my lord. It was discussed in the prior paragraph. Evidence of PW1 was further supported and corroborated by PW2 Abdul Matlib Lashkar, who also deposed that the defendant took 40,000 only from the plaintiff. In cross-examination, defendant failed to extract anything adverse except putting some suggestion which stands nowhere in law without any proof in that regard, my lord. The evidence proved, my lord, and the signature has been compared by the learned trial court, my lord, and found that this is the signature of the defendant, my lord. And the evidence, my lord, even the appellant hearing, my lord, his own evidence, DW2 failed to prove the case of the defendant, the present appellant, my in his evidence, he is stating that he was there in cross-examination. He has denied everything, my lord. He was not present. He don't know the signature of the present appellant, my lord.
Any other point?
And now, my lord, that A1, exhibit A1 and my lord, that was compared by the learned trial court, my lord, and found that this is the signature of the defendant, my lord. There is no infirmity in the order passed by both the trial court and first appellate court, my lord. It's a fit case to uphold the judgment of the trial court and appellate court.
No other point. Third, Mr. Ende Kadir, learned counsel for the appellant, and Mr. Luxford for the respondent. Argument concluded. The
Obliged.
Item 24. Okay. In this case, two substantial question is formulated, my lord. Whether the impugned judgment and decree of the learned court below is sustainable in the failure of the declaration of right title interest of the appellant plaintiff, though the appellant plaintiff right title interest over the suit land and the same is admittedly contesting parties. Two, whether the finding is on my lord 2/3/2022 order dated. And whether the finding given by the learned first appellate court is sustainable on the point of waiver against an estoppel issue notice to answer. My lord, I think, my lord, there is another substantial question already at the time of admission of the appeal, my lord. The liberty is given, my lord. The appellant shall be at liberty to raise any other substantial question of law. And in our, my lord, appeal memo, we have taken the ground, my lord. Ground number 6, my lord. The trial court committed wrong in misinterpreting the provisions of law of section 34 of specific relief act and they wrongly held that the suit of the plaintiff was barred under section 34 of the state act. So, my lord, there is another substantial question. It is very important, my lord, because he, the trial court held that it is barred under section 34 without the prayer available is not prayed for. But in fact, my lord, there is a prayer consequential relief also there, my lord. So there it is necessary to formulate.
Which substantial question?
My lord, ground number, my lord, 6, my lord.
6.
6, my lord. Because, my lord, in my lord, the trial court finding in issue number 2, my lord. In page, my lord, in 42, my lord, page number 42, my lord. In my considered opinion, the suit of the plaintiff is barred by section 34 of specific relief act, which there are the so and so. So, my lord, whether this suit is barred under section 34 of specific relief act or not, in view of the prayer made in the plain, my lord, it is sustainable or not, it is required to be formulated, my lord. So,
Yes.
Lordship, yes, it can be formulated, Lordship. It
Can be formulated.
It can be formulated. They have to, sir, prove it, Lordship.
Pardon?
They have to prove it, Lordship. They have to show it whether this is substantial question of law or not.
it is at the time of hearing.
It is at the time of hearing.
Yes.
Already it is for hearing, Lordship.
That is why.
So at the time of hearing also we can formulate any other substance.
Lordship.
What happened? Okay.
My lord,
Then we will not be able to hear the matter today.
no, my lord. No, they will have to. Admittedly, my lord, I mean, suggest today itself for my lord, Kamalale, but whether the trial court finding of the suit is barred by under section 34 of the Specific Relief Act sustainable in view of the relief claim by the plaintiff. So basically 34 relates to alternative the relief which should be claimed in the suit matter. Already we have claimants.
Heard Mr. P.S. Decker, learned senior counsel assisted by Miss
Below.
learned counsel for the appellant, and also heard Mr. Madam P. Portasetti, learned counsel for respondent number 1. 1, 2, 3, and 4. Mr. Mazumdar first.
5 and 6.
5 and 6. Mr. Mazumdar, Mr. Decker has argued that one more substantial question of law is required to be formulated.
Minor.
Mr. Decker submits that the trial court in the judgment at page number 42 of the memo of appeal
Minor.
has recorded a finding that the suit of plaintiff is barred by section 34 of the Specific Relief Act.
What is the question of law? Suggested, man.
I have suggested, my lord, whether the trial court finding this suit is barred under section 34 of the Specific Relief Act is
It is not suggested, but in the ground it has been mentioned.
mentioned, yes. And
Their grounds. Yes.
in view of the relief claimed by the plaintiff. So basically the relief, whether we should claim another relief also, that is, but already we have claimed some relief method. No, within the volume. Within the volume. Within the within the volume.
Lordship can always formulate, but then so far as the appellate court judgment is concerned, my lord, whether that particular finding of the learned trial court has been affirmed by the appellate court or not.
The issue number 2 has not decided.
Is there any discussion on that point by the first appellate court?
No, but there is no.
Page 44, my lord. The issue appellate judgment, my lord. Issue number 1, 3, 4, 5, 6, and 7. And yeah, that was decided by the trial court, my lord. In view of the decision in issue number 2, my lord, we have decided other issue. No discussion, no supporting. And in appeal, my lord,
No.
page my lord 65. Issue number 1 is affirmative in our favor, my lord. Issue number 2, he discussed 3, 5, 6, my lord. In discussion issue number 2, he has not mentioned anything about section 34, my lord. The finding, my lord.
356 के trial court of finding.
Only file देखने के लिए. Back.
No, appellate court has affirmed the judgment,
Yes, madam.
affirmed the finding of issue number 2.
Yes, madam.
Case
Upon-
number 66.
Without discussing the mail or the particular point mail. Section 34.
So Mazumdar, let there be another
Issue.
yes.
Good, sir.
Well, let's see. Because of the third, like, Mr. Take your learned counsel for the appellant, referring to binding of the learned trial court
Yes, madam.
in respect of the issue number 2 has pointed out that the learned trial court has recorded a finding that the plaintiff's suit is barred by section 34 of the specific relief act. And the appellate court, while dealing with the issue number 2, has affirmed the aforementioned finding of the learned trial court. And as such, there is a requirement of formulation of one additional substantial question of law. And the same has been mentioned in the ground number 6 of the memo of appeal. And therefore, Mr. Dekka has consented to formulate one additional question, substantial question of law as mentioned in the ground number 6. Mr. Majumdar, learned counsel for the respondent number 7.
56.
56. And madam, you have any,
She is supporting us.
madam, what is it? Submits that they have no objection. The event of formulation of additional substantial question of law as submitted by Mr. Dekka, learned counsel for the appellant. Taking note of the submission of learned counsel for both the parties, also going to the judgment of the learned trial court in issue number 2 and also of the learned first appellate court in respect of issue number 2. This court is of the view that there is a requirement for formulation of additional substantial question of law. And accordingly, the following additional substantial question of law is framed. Whether the learned trial court, learned courts below misinterpreted the provision of section 34 of the Specific Relief Act that the right and wrongly held that the suit of the plaintiff was barred under section 34 of the Specific Relief Act. And the suit of the plaintiff is not maintainable. Not maintained. Recessal list the method for hearing on 20.
25 and 26.
In this case, there are two revision petitions. And perhaps, my lord, I don't know, my lord, whether it would be possible for us my lord, to complete the matter today. Because, my lord, it is the second round of litigation. And initially, my lord, PRP, which I have filed against the judgment of 40 crores below, that was, my lord, revision petition was allowed. Judgments were set aside, matter was remanded back to first appellate court, first decision. Now there are two grounds. Decree was passed. One is, my lord, defaulter, and other is, my lord, bona fide requirement. So for the defaulter is concerned, appellate court on remand decided the issue in my favor against the plaintiff. And so far the bona fide requirement is concerned, court has decreed the suit on that ground. Therefore, my lord, I prefer an appeal against one part of the judgment, so far as, my lord, whenever the requirement is concerned, and my friend might have separate with, my lord, revision petition against the, my lord, decision on in respect of defaulter. Therefore, my lord, whether he will start first or I will start first, this is another question. And perhaps, my lord, today.
Definitely, I will start, Lordship.
Today, my lord, whether I will be able to complete the matter through petition, my lord, because the entire evidence has to be, my lord, reappreciated. Because direction was given to examine the matter on the basis of evidence available on record. Therefore, my lord, whether evidence
Regarding that, the remand is not a due date. Regarding the due date.
Right.
So for the due date is concerned, the learned appellate court held there is due date after 1 year. When it is an admitted fact, there is a monthly tenancy. Tenancy is a monthly tenancy. Admittedly, there is no written tenancy agreement. Then the law has been established that in that case, the tenancy is to be considered the monthly tenancy, and the rent due is immediately after expiry of the month. That is the law established. But the learned appellate court held on the basis of a document, held that due date is after 1 year.
And there is a question, my lord, whether they are using a specific finding in respect of due date. So perhaps, my lord, exercising power under, my lord, 150, Lordship may not decide this question. It is a matter for demand at best. Because earlier direction is specific to find out the due date on the basis
No
of
remand is required. It's a second round of litigation.
how court can decide this question.
It is because document is available.
My lord, it is a portion of decision to be made by the, my lord, matter was remanded back with the direction to decide this question. That whether the evidence was properly appreciated or there is a non-appreciation of, my lord, evidence on record. That part can be examined only by the appellate court. Or if Lordship is otherwise inclined to take, my lord, hear the matter and decide the question, it is a different question. Due date is a crucial, my lord, issue involved in this. As far as the bona fide requirement is concerned, as you Lordship knows, my lord, law is well settled. It may be the privilege of the landlord, but there are some parameter laid down. Number of this, when I referred, my lord, I have taken a specific ground. what is the, my lord, appropriate concept of bona fide requirement. Whether it is the absolute privilege or it has to be testified by some other, my lord, factor. For example, my lord, whether it is a bona fide, whether it is, you know, just, proper, whether it is tainted with any malafide or my lord, oblique motive. These are the, my lord, factors to be taken into consideration while, my lord, declaring a suit on the ground of bona fide. So, my lord, I think, my lord, now it is almost, my lord, 3:45. You will take at least, 45 minutes. I will take 45 minutes. And like, ultimately, matter will have to be kept as part of. So, Roshi may keep them and, my lord, fix a date, my lord, so that we can argue the matter properly.
Okay.
Date may be fixed.
Date may be fixed. As they go.
2nd September.
Okay. As agreed by learned advocates of both the parties, let's leave the matter on 2nd September
Tuesday.
as top of the list item.
Lordship.
I mean, there is an interim order, my lord.
Interim order passed earlier self-contained.
27. I'm obvious.
May it please the Lord. Look, we had filed an IA. We had filed an IA under Order 41 Rule 27 to bring on record a document, madam. That IA is coming up for the first time. But the issue in brief is that, my lord, I am the builder, my lord. There was an agreement to sell with my learned friend's client. Now there is a dispute with regard to the measurement of the villa.
Let us first dispose of this IA.
Yes, but this IA has been filed basically under Order 41 Rule 27 for production of some document at the appellate stage. Well, and it appears when the documents which they are now trying to produce is in respect of a different villa.
Yes, we are saying that it is in respect of a different villa.
Different villa. So, well, let us file an objection to this. We'll file an affidavit against this. Then you will have to consider whether under Order 41 Rule 27 will allow them to produce this document or not.
Then we will not be able to hear the other matter.
Yes.
Heard Mr. Deca, learned for the applicant. This interlocutory application under section 41. The order 41, rule 27 of the Code of Civil prepared by the applicant for allowing to produce documents, namely the joint site visit report supplied on 14 May 2024, Annexure 8. The calculations done by the appellant stroke applicant while calculating the size of the villa within bracket Annexure P, and the letter dated 2nd September 2024 within bracket Annexure C by the GMPA as part of the record of the present proceeding. Mr. Mozumdar learned senior counsel appearing for the opposite party submits that he may be granted some time to file objection to this application. Where is accordingly allowed, this is a list the matter after 1 week.
Well,
after 1 week.
Well, let it be 2 weeks when the client is actually stays abroad. How the affidavit will have to be let it be on fixed on 7th May. 7th of August. In the meantime, we'll file.
Okay, 7th of
August.
May I brief?
Yes.
In this matter, the respondents were the plaintiffs who have filed the suit for declaration, partition, possession, rendition of accounts regarding a property which was purchased in the name of the partnership firm. The present plaintiff and the deceased wife or deceased mother of the defendant were the partners. However, the mother of the defendant was expired in the year 1992. Through the process of the present suit, the respondent was claiming to be one of the partners in the partnership firm, through which partnership firm she was claiming to be the one of the partners, thereby claiming a relief for declaration that to be declared as one of the partner in the firm and to be the owner of the property. In that suit, the present appellant was the defendant number 4 and 5, that is husband and wife. The defendant number 4 and 5 has moved an application under order, moved their written statement along with a counterclaim. The counterclaim also filed separately along with the written statement. After filing the written statement and the counterclaim, the defendant, the present appellant has moved an application under Order 7, Rule 11, A, B, and D. However, the learned trial court was pleased to dismiss the suit of the respondents as per Section 69 to be barred under Section 69 of Indian Partnership Act. And at the time of passing the order, in 2 lines, the learned trial court has also dismissed the counterclaim of the present appellants. Thereby mentioning, kindly see the page number 23 of the order. That the instant suit has a counterclaim filed by defendant number 4 and 5, praying for the reliefs against the plaintiff relating to the suit property which was purchased in the name of the firm. Like the plaintiff, the defendant oblique counterclaimants have also prayed for the reliefs emanating out of the contract of partnership. The defendant oblique counterclaims have stated in their pleadings that the firm is an unregistered one. That being so, their counterclaim is barred under Section 69 of Partnership Act. However, I have never claimed to be one of the partners in the partnership firm. Secondly, in the counterclaim, kindly see I have also filed my counterclaim along with the present appeal. My prayer in my counterclaim was regarding seeking of possessory rights and better title than the plaintiff by way of adverse possession, not by the way of partnership. I have also filed, and specifically in Order 8, Rule 6D, it has been specifically mentioned that nevertheless, if the main suit has been dismissed, the counterclaim should not be the counterclaim should be proceeded with. Order 8, Rule 6D. It has been specifically mentioned. My prayer is totally different from the prayer of the respondents in their main suit. But the learned trial court had dismissed my counterclaim also, that is for the adverse possession. And as per the counterclaim, it has been specifically mentioned in CPC that counterclaim should be treated as a separate suit. If I have filed my written statement, obviously I will take defense against the averments of the plaintiff. And along with that, I can take additional reasons against the plaintiff in my counterclaim. So my counterclaim should not be dismissed, as well as the application has been moved by the present appellants under Order 7, Rule 11. The Honorable Court suo motu declared that it has been emanating out of the contract. However, no partnership contract was also placed before the Honorable Court. And through this appeal, I am only challenging the part regarding dismissal of my counterclaim.
So let us say what Section 69 of the Partnership Act states.
69, the learned trial court has also mentioned.
Yes.
69, Section 69 in its judgment. Kindly see.
Page 17, 69. Effect of non-registration. No suit to enforce a right arising from a contract or conferred by this act shall be instituted in any court by or on behalf of any person suing as partner in the firm against the firm or any person alleged to be or have to be a partner in the firm. Unless the firm is registered.
Your firm is not a registered firm.
Yes, sir.
Admittedly, your firm is not a registered firm.
Yes, it was not a registered firm. I was never the partner in the firm. My late mother in the 90s was the firm. I am claiming for the adverse possession in the property because, and the respondents were claiming to be one of the partners and the rightful owners of the property as half of the owners of the property through partnership firm. I was only claiming adverse possession because I am in the possession of the property since more than 32 years. I have also filed a declaration given to me by the respondent that yes, it is under the control without any interruption of the present appellants. I've also filed that MOU. And my relief seeking in the counterclaim is totally different from the plaintiff. I have taken the plea that their firm is not registered in my 711. So their suit should be dismissed as per 69. And as per kindly see Order 8 Rule 6D also, it has been specifically mentioned that nevertheless, if the 6D, nevertheless, if any case, suit, plaintiff, respond is state continued or dismissed, the counterclaim should be continued. Because the prayer was totally different. My relief was totally different from the plaintiff.
Maybe, but the learned trial court has held that because of this section 69.
Yes, and 69 doesn't apply to me because I was never the partner, nor I am claiming through any right of the through any contract of partnership because partnership deed was also not available at that time. Nothing was produced there. I was only claiming adverse possession. If I in any scenario, if I am in possession of any property and another one is claiming that I am the partner, then it's okay. But I am claiming only the possessory right through adverse possession. I'm not saying that I am the partner in that firm. I specifically mentioned, kindly see the prayer of my counterclaim also. I'm only claiming possessory rights. I've never stated that I'm the partner in their partnership firm.
Yes, what is your submission?
Lordship, basically this suit land, it was purchased by a partnership firm. Now, I am one of the partner of the firm, the respondent herein, along with another person I'd purchased. Now, the plaintiff herein is one of the legal heirs of the concerned partner of the firm who is since deceased. So his rights basically flows from that particular deceased plaintiff. There is one aspect of the matter, Your Honor. And since our firm was unregistered, as is mentioned by the learned trial court, which have not challenged yet before the court, so now by virtue of it being an unregistered partnership firm, the bar of section 69 comes into play. Moreover, Your Honor, if I may just submit.
In respect of the counterclaim also.
In a counterclaim also, they are seeking right by way of adverse possession. But if Your Honor peruses the counterclaim, nowhere it has been mentioned that the possession, it is settled position that possession of a property does not entitle the person to claim adverse possession. Unless that particular property was held hostile to the original owner of the property and it was well within the knowledge of the original owner that yes, this property is being held against us. In this counterclaim is completely silent this aspect of the matter, Your Honor. And moreover, Your Honor, in the counterclaim, Your Honor, if I may submit that in the counterclaim, another averment has been made.
Another
averment has been made that the concerned, that the plaintiff, that the appellant herein entered into an MOU with us in the year 2020, wherein we are set to receive 4 lakh rupees from them. You know whether this mutually destructive plea can find its place in the court because on one way they are claiming title by way of adverse possession, on the other end they are entering into an MOU with us, paying us 4 lakh rupees for the purpose of we relinquishing our rights over the particular plot of land. This in itself, Your Honor, a mutually destructive plea which cannot sustain, Your Honor. So the two basic submissions which I like to make before Honorable Court, Your Honor. First, it was an unregistered partnership firm. Their rights flow from one of the deceased partner of the firm, if at all they have any right. And second, this plea of adverse possession, Your Honor, the counterclaim is totally absence of the requisite pleadings to claim title.
Let us see the counterclaim. Page number?
Page number 66, it is the prayer in my counterclaim. I have only claimed the ownership rights. That being possessory rights being given to me
Page
by
number?
page number 66, it is the prayer. I've never mentioned that I'm the partner in the firm. A decree of declaration in favor of the counterclaimant, answering defendants and against the respondent, please may kindly be passed by declaring that the counterclaimant, answering defendants are owner by way of exclusive possession of the lands in dispute. That is property, land at mentioning 8 biga, that is the
Since when?
yes.
Since when?
Since when? I have mentioned that also since more than 32 years. In 2005, adverse position, I was.
In which paragraph of?
I'm
counterclaim you have
telling the page. I specifically mentioned in the page of the counter. Page number 27. In the last lines, I said that that for which the counterclaimant answering defendant become the owner by same by virtue of adverse possession of the same, which adverse possession of the answering defendant number 4 and 5 has become maintainable in the eyes of law in the year 2005. That is from the year 1990 till 2005. That is 12 years in between the period of plaintiff did not file any claim over the suit property specimen A and B. I specifically mentioned the date. And they are only everywhere in the before the London trial court and here in the appeal, they are only saying that MOU, and they have defended that MOU is unregistered, being notarized. It is not maintainable in the eyes of law. However, I have taken the defense thereby on the basis of declaration.
But your entry to the aforementioned land is on the basis of the unregistered document.
No, there is also a declaration, sir. There is also a declaration. MOU is not maintainable in the eyes of law. It can be taken in evidence. I agree with them. But as per the declaration, it is not required as per the registration to be registered. They have given me registration. I filed before the Honorable Court that they have also given a declaration that yes, he is in the control and possession from 32 years and now he has come before us and we are only demanding this amount. That too being having family relations. And I after that also sent legal notice to them. They have replied me. It needs a complete trial. And I'm only claiming to be adverse possession. Specifically, dates have been mentioned. They didn't prefer any appeal against the order of the trial court. It is binding upon them. And now my counterclaim is suffering.
Where you have mentioned the date?
2005.
Is it the date?
Page number 27, 1990 till.
Is it the date?
Yes, sir.
Where is the date?
Sir, till year 2025.
5.
Yes.
2005.
2005.
In which month? On which date? Let us do one thing. You come prepared on the law of adverse possession.
I will prepare on adverse possession.
Yes. Heard me, sir? What is your name?
Sachit Sharma.
Learned counsel for the appellant and Mr.
M. Shah.
Learned counsel for the respondent. Heard in part, place the matter on.
Can it be, sir, 12th or 13th? I'm requesting.
August.
September, 10th or 12th. September.
Okay.
11th September. Highly obliged.
May I please, your Lordship?
Yes.
Lordship, Senior Counsel Mr. A.C. Sharma is out of station. Kindly the matter may be taken up after 2 weeks.
After 2 weeks.
Yes.
Yes, Mr. Gandhi.
As per the last order, my lordship has a look at the last order. The specific query was, I have no objection to the prayer for adjournment as such, but I'm only saying is that as per the last order, specific query was put to the learned senior counsel as to whether he wants to continue with this revision petition or he wants to withdraw it and file an appeal, second appeal that is. Because the entire crux of the matter is that their claim is based that he is not a tenant. There is no tenant-landlord relationship. My Lord Justice Barua then put the query that if he is not a tenant, then this civil revision petition will not be maintainable because it is under the Assam Urban Areas Rent Control Act. So whether you examine that aspect of the matter. So in that light, my lords,
That has to be answered by Mr. Sharma only.
yes, it has to be. So I am only praying that let there be a fixed date after 2 weeks, my lord. Lordship will take it up and either the matter has to be heard. Or
Exactly, by learned advocates of both the parties, rest is always the matter of.
can it be
Interim order, Lordship may be.
heard? 3rd September.
Interim order passed earlier shall continue.
Obliged.
Lovely.
Item 35 and 36.
Lordship, my respondent, my senior is not feeling well today, so he has not come to the court. Kindly fix the matter after a week.
Lordship, they can mention in the morning. We have been sitting for this case early morning. You could have mentioned it in the morning.
I am instructed letter, Lordship.
And it was not even heard, Lordship, but it has come as part heard. Hearing did not.
Kindly fixed.
So one IA was filed.
Yes.
For
order
the
41.
matter was partly heard.
No, that I Lordship was filed later on because we received the copy on 27/6.
No, that IA is on a part heard.
Oh, that is with her Lordship because there are two cases. I am in 36. She is in 35. In my case, I was filed later on, order 41. Fine.
When can it be fixed?
After a week, Lordship.
After a week.
Any.
28.
28.
Lordship.
Much obliged.
37.
Obliged.
Pattern meter.
No. Yeah. Yes. This appeal is basically against an award by the Commissioner Workman Commission.
What is the limitation period?
2 years.
Yeah. So the petition has been filed after 2 years.
Not 2 years. This is a case, Lordship, where presumption has been, according to them, it can be presumed that he is dead on the basis of 107 of the Evidence Act. They took the presumption and decided that person has been dead. And thereafter, Lordship, they have filed this case. That is also after more than 3 years. And basic question is, Lordship, that question has been decided by the Honorable Supreme Court, whether the Commissioner under the Employees Compensation Act can take the presumption when police has submitted a final report under section 40649 of IPC against the driver, saying that vehicle has been stolen by the driver and it has been sold out the market. And the police has submitted a final report, and final report has been accepted by the owner of CGM on the basis of FIR filed by the owner. Lordship can see the FIR in the LCR at page 15 of the LCR.
What is the decision of the Supreme Court?
Supreme Court decision I have already given, that is Sorumai Gogoi. This is also from Guwahati High Court. Supreme Court reported in 2008 for SEC 572. Judgment is with the file, Lordship. Last page of the file. 2008 for SEC 572. Lordship got it. Para 18 and 23. May I read, Lordship?
Yes.
Section 108 and 109 of the Evidence Act are founded on the presumption that things once proved to have been existed in a particular state are to be understood as continue in a state of until contrary is established by evidence, either direct or circumstantial. Said provision can be invoked in a legal proceeding by the death of a person may be in issue. Section does not say that presumption would be applicable in all situation. It shall not apply in respect of a person who absconds from justice, nor evade a trial or otherwise charge or commission of a grave offense. As he in that situation may not communicate with his relations. Furthermore, in a case of his nature, it is also difficult to rely upon the self-serving statement made by the claimant that they had not heard their son for a period of 7 years. Commissioner Workmen Compensation or the High Court did not assign a reason as to why the fact disclosed in the charge sheet, which was filed upon the investigation of that Bipul Gogoi himself had ran away with the vehicle, would not be relevant fact, particularly when the cognizance had been taken by the competent court of law on the basis hereof. Thereafter, Section 3, 1923 would be attracted only when the conditions precedent thereof are fulfilled and not otherwise. To come within the act, and this is not relevant. Now, Lordship, in this particular case also, the Bipul Gogoi was, FIR has been filed, Bipul Gogoi was absconding and vehicle has been, according to FIR, vehicle has been stolen by Bipul Gogoi. And police has filed charge sheet that he is an absconder. In this particular case, police has submitted a final report that is on record.
Have you gone for this decision?
Lordship, there are two things that I would like to point out here, Lordship.
Pardon?
There are two things that I would like to point out here, Lordship. The first, Lordship, in the Sorumai Gogoi Lordship judgment, the thing is that the person who is supposed to be missing, who is declared, who is presumed dead, a case has been registered against him. He has been declared as absconder, and it has also been stated by the police that he has stolen the vehicle. In our case, it is not so, Lordship. In this case, it is not so. Also, in the Sorumai judgment, it's given that it has to be determined on a case-to-case basis. Second of all, Lordship, this ground that they have been raising now, Lordship, it was not raised during the trial, Lordship. Even in the appeal memo, Lordship. The question regarding the maintainability of this petition of the award of the employees' compensation of Commissioner Lordship as regards 108 and 107 of the Evidence Act, that has not been raised. The only plea that they are raising is the limitation. In the WS, Lordship, of the, if Lordship goes to the trial court, Lordship, in the WS and also in the appeal memo, Lordship, this plea has not been taken specifically. The main grounds on which this MFA has been filed is the limitation, Lordship. And regarding limitation, Lordship, I'd like to read out the proviso provided in Section 10, Lordship, of the Employees' Compensation Act. Okay.
Before that, Lordship can see the affair at page 15 of the LCR. Lower court record.
Page number
Page number 15 of the LCR.
50. Where is the final report?
Final report, Lordship will find at page 21. Last portion will find Lordship তদন্তৰ দেখা যায় যে এই মোকৰ্দমা পদকীয়া এটা মিছা ওচৰীয়া তেওঁৰ গাড়ীখন ভাড়া মাৰিবলৈ যোৱা বুলি কৈ যায় কোনো অজ্ঞান স্থানত গাড়ীখন বিক্ৰী কৰি তেওঁ কৰবাত আত্মগোপন কৰি আছে
That was the case, Lordship. A charge sheet would have been filed. A charge sheet should have been filed, Lordship, if he was supposed to be absconding. No charge sheet was filed, Lordship. Only final report was filed. And that too was accepted, Lordship.
And that ওপৰৰ কাৰণৰ লিখিত মোকৰ্দমা under section 406 ধাৰাত সত্য কিন্তু সংসূত্ৰবিহীন বুলি আইনৰ আদালতে এই চূড়ান্ত প্ৰতিবেদন দাখিল কৰিলো তদন্তৰ যথাসময়ত গোচৰীয়াক জাননী যোগে জনাই দিয়া হ'ল ইয়াৰ লগে গোচৰীয়া প্ৰথম জাননী গাঁঠি দিয়া হ'ল চুৰিকাৰণৰ মূল্য ইমান টকা only to get the insurance আৰু গাড়ীখনৰ সংসূত্ৰ পালে গোচৰীয়া জীৱিত কৰিব পৰা যাব গোচৰটো পুনৰ জীৱিত কৰিব যাব
That's all right. If in the case of Sorumai Gogoi, charge sheet was submitted and he was declared absconder, that actually this case may be different from that case.
Yes, Lordship.
according to them that against next judgment in Supreme Court judgment on this point whether commissioner workman compensation can fix the date regarding date of a person court can take presumption can be taken by the only civil court regarding lordship the date of a person within 7 years commissioner workman compensation cannot take the presumption regarding date lordship will find this judgment
So, Lordship, that point should have been raised.
That pen
in
has
the
been-
written statement, in the appeal memo, has that point been raised? They are not contesting on that ground, Lord. They are just contesting on limitation. They have not mentioned anything regarding the power of the civil court, the power of the employees compensation, commissioner, Lord. The simple case is on limitation, Lordship. And regarding limitation, Lordship, proviso is explicit, Lordship, in here.
Section?
Section 10, Lordship, proviso. Provided further that the commissioner may entertain and decide any claim to compensation in any case, notwithstanding that the notice has not been given or the claim has not been preferred in due time as provided in this subsection, if he is satisfied that the failure to do to failure so to give the notice or preferred claim as the case may be was due to sufficient cause.
That is, Lordship, before filing a case under the Workmen Compensation Act, notice should be served to the insured that compensation should be given for death of a person. That notice regarding this notice, Lordship. regarding notice now. If Lordship, the presumption is also taken within 7 years when case has been filed, Lordship will say. They are arguing again and again regarding limitation. I will show. Lordship will find when case has been filed. Lordship will find at the page 3 of the page 2 of the appeal memo.
Take a minute. Yes, Mr. Goswami, section 23 of the Employees Compensation Act.
Lordship.
Power and procedure of commissioner.
Lordship.
Commissioner shall have all the power of a civil court.
Commissioner has the power of commissioner will court power for the purpose of taking evidence on oath and enforcing attendance of witness, compelling production of documents and material object. Commissioner shall be deemed to be civil court or purpose of section 195 of the Code of Criminal Procedure. Beyond that, no.
So what section 195?
195. 195 is also the criminal proceeding regarding giving false evidence. 195 CRPC. False evidence before the court. Lordship, regarding limitation, Lordship kindly say page 2, para 3 of the statement. Regarding limitation also. Law point can be argued at any stage, before the Supreme Court also.
Paragraph number?
Paragraph number 3. Page 2.
Of the trial court?
No, Lordship, the appeal memo. Lordship, got it? Affair was lost, Lordship, got it? Paragraph number 3.
Yeah.
Affair was lost on 20/12/2005 regarding loss of the vehicle by the insured. In Volomur station, police submitted final report on 31/3/2008. FR number 23 of 2008. Therefore, the present WC case has been filed in the year 2016. If presumption from the date of 2005, it is 2012, Lordship. And present case has been filed in 2008. That is after 3 years. If presumption is also considered that within 7 years, presumption can be drawn by the WC court also, then also it is after 2 years.
The presumption was drawn after the final report was accepted. How can we do presumption of before the final report was accepted?
How he can take presumption? Presumption can be taken by the court, civil court.
Lordship, that question, Lordship, that is the fundamental question. That is not the point that they have been arguing upon. They are raising it at the time of hearing. The entire appeal memo is based on limitation, question of limitation, Lordship. Regarding that, Lordship, limitation point, I have a judgment of the Honorable. It was Punar 2023 to Supreme DAU 187.
2023.
2023 0.
Well, 0. 187. What's Samil?
Question is not regarding whether presumption can be taken or not, Lordship. The question whether
Lordship,
it's
in
the
this
power of
in this particular case,
power to
Lordship,
condone delay, whether the power to condone delay is the exclusive, I mean, it's vested in the commissioner, Lordship. And regarding this paragraph 15, Lordship, of the judgment.
No, you see, when the FR was accepted by the trial court,
FR was accepted by trial court. FR was accepted on 27/7/09.
That is, Lord.
09.
Yes, Lordship.
If we count the period of limitation, then when it will expire?
2 years, Lordship.
2 years.
2 years.
After 7 years, Lordship, we have filed after presuming. After we have filed the present petition has been filed in after a gap of 7 years, Lordship.
7
Indicating
years
that
from?
7 years from the date of acceptance of the FR by the trial court, Lordship.
No. Whether it will be counted from the date of filing of the FIR or from the date of filing of the final
Lordship, at
report
the
or
time
something.
filing of the FIR, the investigation was pending. When the FIR was submitted, the investigation was deemed to be completed. From the date of FR, actually, Lordship, that should have been counted. That is to be counted, Lordship. Only after
From
acceptance
the
of
date of filing of the acceptance of the
FR.
final report.
Final report, Lordship.
Final report.
That will give finality to the investigation. Otherwise, Lordship, in general, investigation may go for 10 years. This is the case, Lordship.
Vehicle lost on 15/12/2005. If that is the date of loss, the person, 7 years will come on 2012. 2012. If presumption is drawn, that person is not, section 107 of the Evidence Act, is not known to the person for 7 years by the person who is know him. Then it is 2012. After 2012, he can file a suit for declaration that person is not known, he should be declared civil debt. After that, it is 2 years. If there is a decree from the civil court declaration that he is declared to be civil debt, then within 2 years. There is no declaration to that effect by the civil court. Secondly, Lordship will find in the LCR. If you want to argue, Lordship, I will stop. Lordship, there is no petition for condonation of delay in the trial court. And there is no evidence except the claimant. Claimant has examined himself as a witness to prove his case. There is no any other witness. Police has not been called to prove the case. Neither any person has been called to prove the case. There is no petition for condonation of delay regarding that. And there is no petition for presumption that person has been declared dead after 7 years. There is no such petition to the Commission of Workmen Compensation. I have verified the LCR today morning also.
Lordship, in the prayer portion, Lordship, of the petition, Lordship, in the Workmen Compensation, it has been given. It is therefore prayed that your honor may be pleased to admit this application after condoning the delay in filing of the instant claim petition and pass an award directing the opposite parties to pay a sum of rupees 7 lakhs or more. So, no, this is a Workmen Compensation Act, Lordship. No separate petition is needed in this case. Thus, prayer will suffice. And that has to be condoned by the Employees Commissioner, Lordship. He has condoned the delay.
Whether there is an order for condonation of delay, whether court has passed any order that delay has been condoned.
Lordship, there is a ground. Here is an explanation which is given.
Lordship can see the judgment, another judgment I have shown, Lordship, that is reported in 2004.
Please let me complete. Lordship, if in the judgment that I have just presented now, Lordship, I am just going to one paragraph, Lordship, paragraph 15, page 4. Last page, Lord, paragraph 15. Coming to the point of limitation,
It is well established that the question of limitation is a mixed question of fact and law. In as much as proviso to section 10 Employees Compensation Act 1923 clearly empowers the learned commissioner to condone such delay. If the same is properly explained if the same is properly explained. Therefore, whether the claim is barred or whether it is a case for exercise of power under proviso to section 10 is a matter to be dealt with by the learned commissioner and not by this court. So let's say section 10, it empowers the commissioner totally to condone the delay. If he is,
No, that's all right. Whether the commissioner has passed any such order.
Your lordship, he has given the reason, Lord. Paragraph 9 of the judgment, lordship.
No, at the time of execution of the application.
The time of admission, lordship, a verbal order was passed, I think, lordship.
Verbal order?
Lordship, maybe.
Maybe.
So, lordship, but lordship, in the judgment, lordship, it's given in page 9, lordship. Before the last paragraph. The next argument that the claim petition has not been filed within 2 years of the occurrence of the accident, and as such the petition is liable to be dismissed, is not tenable in this particular case. As such, the claimant's son is presumed to be dead after 12 years from the date of his missing. The petitioner's son, Nurul Haq, driver of vehicle number Iman, went missing on 15/1/2005. The volume of police personnel submitted the final report to the Chief Judicial Magistrate, Kamrup Metro, on 27/1/2009, who confirmed that Nurul Haq Ali was not alive. But the civil death of Nurul Haq Ali can be presumed after 7 years of his absence. Calculated on basis of this procedure, the claim petition is found to have been filed within this limitation period. So, lordship, after the commissioner has found a sufficient reason under proviso to section 10, lordship, he is empowered to deal with this petition. And then, lordship, regarding the, during the trial, not in the grounds of appeal.
Let us do one thing.
Lordship.
We adjourn the matter. You come prepared on that point. From which that limitation will be counted? Limitation of this 7.
Lordship.
7 or 12 years?
7 years.
7 years. But here it has been mentioned as 12 years in the judgment.
That is also wrong. That is also wrong. And lordship, that finding also wrong because police has not final search sheet stating that person has been dead. He cannot be found. Police has said he has absconded by selling the vehicle. The finding arrived by the commissioner is also wrong. Final report said he has absconded by selling the vehicle.
In that case, lordship, a charge sheet should have been there. If the police is shifting the blame upon the respondents to find their son, they cannot do their duty. It's incumbent upon the appellant company. They should have, they have agents everywhere. They could have charged. They are just trying to, shift the blame to us, burden to us, lordship.
And it is also required to be examined whether the ratio laid down in the case of
Yes, Lord.
is applicable here or not.
Yes, Lord. That has been explicitly mentioned that it may differ from case to case. Lordship. It is not a fixed straitjacket formula, Lord.
Okay, you see some of the decision of the Supreme Court from which that this 7 years has to be counted.
Lordship.
Third is S.K. Goswami, learned counsel for the appellant, and task for the respondent. Third in part is the matter sorted.
Obliges.
38. 9.
May I please the law? I am for the respondent number 1.
Appellant absent.
Appellant is absent.
Oh, how many times?
Lordships.
to the listed after 25 to 2020 only.
Urgency is required because one of my room they occupied the lock and key. That's why I mentioned that.
And it is put a appellant on call. How about Mr. Bormi and Learned Council put a respondent number?
I respond number 1.
Respondent number 1 present. Please the matter after 1 week. In the case of subsequent non-representation of the appellant, appropriate orders will follow.
We are both in the same case, Lordship. Lordship, fix another date because today is not possible.
Okay. It's agreed by learned advocates of both the parties. Is the matter.
God bless.